Oyez, oyez, oyez. All persons having business before the Honorable, the United States Court of Appeals for the District of Columbia Circuit are admonished to draw near and give their attention, for the court is now sitting. God save the United States and this honorable court. Be seated, please. Case number 25-7046. Mohammed individually and on behalf of proposed class members et al., appellants, versus Kimberly Clark Corporation et al. Mr. Collingsworth for the appellants, Mr. Zients for the appellees.
Good morning.
Good morning.
And start when you're ready.
Good morning, Your Honors, and may it please the court. I am Terry Collingsworth, and I'm with the International Rights Advocates, and we represent the 13 men who brought this case, who were among many victims of trafficking and forced labor being moved from Bangladesh to Malaysia to work in various factories, including the Brightway factory at issue here. Kimberly Clark Corporation, I'll call them KCC, and Ansel have conceded that the 13 plaintiffs were trafficked and forced to work in the Brightway Group factory. And the issue here is whether they, KCC and Ansel, are liable with Brightway for the forced labor and trafficking. Overall, we're here to look at the scope of the Trafficking Victims Protection Act, the TVPRA. Excuse me. And in doing so, I'd like to read a brief quote from the sponsors of the TVPRA, who filed a brief in the Supreme Court in Nestle USA versus Doe, speaking about the scope of the TVPRA. And they said, quote, "It is not enough to target the traffickers themselves. Effective anti-trafficking policy requires disincentives directed towards those who benefit from trafficking, including corporate actors who knowingly profit from trafficking in their supply chain." And that's at 2020 Westlaw 6322316 at 1920. And we submit that that's the scope, the intended scope of the TVPRA applies to both KCC and Ansel here, because they, according to Section 1595A of the Trafficking Victims Protection Act, they knowingly profited from forced labor in this case. Now, we have a lot of issues here. Whether, I'm going to briefly list them, whether there is a 1595A venture, whether KCC and Ansel knew or should have known of the forced labor and trafficking at Brightway, whether the statute applies extraterritorially in this case, and then we have common law claims for unjust enrichment and negligent supervision. I'd like to initially focus my limited time on the two factually intensive questions, whether there was a venture and the state of knowledge for KCC and Ansel. The issue of extraterritorial jurisdiction, of course, I'm here to respond to any questions, but it's well briefed in our opening brief at 10 to 27 and the reply brief at 5 to 14. And we have an amicus brief filed by the Legal Scholars Group.
Before you move off of extraterritoriality, so under RJR Nabisco, there are two ways. I call them steps. They're not exactly steps, but either the statute as a whole applies extraterritorially, or the focus of the statute could be domestic. So if just assume for a minute that I don't think the statute applies extraterritorially, what is the best evidence that the plaintiffs have put forward that there is a domestic effect in the United States? Because the forced labor all occurred abroad.
Right. Thank you, Your Honor. Well, I hope we're not done with the issue of whether it does apply extraterritorially. I think that in the briefs in all of the cases, particularly in our opening brief at 10 to 11, we have about a dozen cases that say that it does extend entirely extraterritorially. But I think in terms of the domestic application, part 2 of R.J. Reynolds, 1589B of the forced labor statute makes it an offense to benefit from the forced labor itself. And we think in the amicus brief and our brief both emphasize that 1589B clearly makes it a domestic violation if you benefit in the U.S.
So are the benefits, is the benefit just sufficient for it to be just commercial benefits, just profits?
That's
I
the
mean,
thing.
does there have to be some connection between those profits or some action that the defendants have taken to show that they're in a venture and that, they're actually, they have to have shouldn't there have to be some greater effects domestically?
Well, the question in 1595A itself is some form of benefit. And in this case, it is, in fact, financial. It's profit. They had low-cost gloves produced at a factory that was using forced labor and trafficked labor. So our argument under 1589B is that they, sitting in the U.S., received higher profits from the lower costs of that factory. And of course, that assumes they are in a venture, which I'm planning to cover.
Do the plaintiffs allege anything other than profits occurred domestically?
Well, they have the benefit of a steady supply source of cheap labor gloves from Brightway because of their long-term relationship with the factory. But at the end of the day, it is profit. They're benefiting from the cost savings of not having a factory that meets their own standards that they claim they try to apply.
That's an argument that 1589B, the substantive law, applies to knowingly benefiting in the United States from trafficking abroad.
That's correct.
In the lingo of extraterritoriality is to say that the focus of 1589B is on the knowingly benefiting.
That's correct, Your Honor.
But even if all of that is true, you still have to show that the cause of action applies. There's a step 0 to RJR, which is you have to separately analyze substantive law and cause of action. And if you just apply RJR, the focus, even if you have domestic conduct, the focus of the cause of action is on the injury. And here, the injuries all happened abroad.
The 1589B expands the focus, which we did plead, to also whether the companies benefited from the forced labor. So the forced labor absolutely occurred abroad, but whether you benefited from it in the United States, and it makes it a domestic application, it's in our complaint, and 1589B only exists. It would otherwise be redundant to make sure that the person benefiting from it in the United States is equally liable to the direct perpetrator, and that's textual.
That's just an argument that extending the geographic scope of the substantive law determines the geographic scope of the cause of action, that there's no separate requirement of a domestic injury for a cause of action.
Well, the domestic injury is the profiting from. And
no, the domestic injury to the plaintiffs is being trafficked on the other side of the globe.
Right, and that is their cause of action.
That is not domestic. None of the injuries is domestic.
None of the injuries are, but 1589B explicitly makes it.
1589B is substantive law.
Yes.
Just like in RJR, the substantive law 1962 applied to domestic and extraterritorial conduct, and that didn't answer the question about the geographic scope of 1964, the cause of action for which the court said you need a domestic injury.
They didn't have a...
Why doesn't that logic equally govern here?
Because they didn't have an explicit statute like we do, 1589B, which simply says whoever knowingly benefits financially, and that's case Kimberly Clark.
RICO, which incorporated predicates, some of which were just as extraterritorial as 1589B, and some of which were exclusively extraterritorial.
1589B is exclusively domestic, and that's what both we and the legal scholars establish in our briefing on that it exists solely to allow for that domestic injury. And then if you look at the, The Rodriguez versus Pan American Health Association specifically held at 29 F 4th 706 at 716 that the financial benefit, I'm quoting, the financial benefit that violates 1589B is itself wrongful conduct and occurred in the United States. And that
case tends to support you on the proposition that 1589B covers domestic benefiting.
Yes,
Based
absolutely.
But that doesn't answer what's troubling me with your position, which is the difference between the substantive law and the cause of action, which is what RGR was all about.
Well, again, RGR has had two steps, and we think we satisfied the first step, but the second
Does the
step.
cause of action here in 1595A use the word injury? That's what Judge Katsas was talking about, because it did use injury to business or property in RICO.
It simply says an individual who is a victim of a violation of this
So
chapter.
it doesn't require an injury in the United States.
No, it does not.
Injury to property or business.
No, it
just
does not.
Requires that the plaintiff be a victim of a violation of this statute.
That's correct. And
I think a plaintiff can be a victim of a violation without an injury from the misconduct.
they have to show that they were a victim of one of the substantive provisions of the chapter. And in this case, we're alleging they were both forced labor and trafficking. But 1589B does not require that we demonstrate that injury. It requires only that we demonstrate a benefit to KCC and Ansel.
Can you be a victim if your injury occurred abroad rather than domestically?
Yes, if it applies extraterritorially, but I think.
Is there any question that any of these, I hadn't thought at this stage, that there was any question that any of the plaintiffs here were severely injured by the forced labor and trafficking?
They would, in the allegation of the complaint, we show that they were subjected to slavery-like conditions. They suffered physically, they suffered mentally. They indeed were very much physically injured by the actions that occurred to them and that are really undisputed in this case. I see I'm really eating into my rebuttal.
Put aside geographic scope. Just, do you agree that the cause of action, the word victim in the cause of action requires both some kind of injury and some kind of causal relationship between the misconduct and the injury to be a victim?
Yes, you have to demonstrate that you were injured you were a victim of one of the substantive causes of action. 1589 and 1590 are the two that are at issue here. I see that I only have 3 minutes left and I wanted some.
Can I just ask you another
Sure.
question about that, which is, even if we assume that the benefits that could just be simply profits in the United States, why wouldn't the plaintiffs have to show that there was participation in a venture that occurred domestically? You know, something specific about how the companies participated in a venture domestically. I don't see any allegations of that sort in the plaintiff's complaint.
I don't think we have to show that. I think we have to show that we have to satisfy 1595A, that they were participants in a venture that in fact engaged in the forced labor and trafficking. So their participation, they don't have to be sitting in Malaysia to participate in that venture. We allege that they participated in it by investing in this factory and by supporting it across the years and other indicia that we allege in the complaint of their support for that and their participation in the venture.
So then there would be no limitation. I mean, basically any domestic corporation could be held liable for forced labor abroad if they were participating in a venture. So there would be no extraterritorial limit at all under.
According to 1589B, no. But there's a huge limit. They have to have first been participants in the venture that did the wrongful acts. And then if they did, they can't sit in the U.S. and say, we didn't do it because we're here in the U.S. No, you benefited from it here in the U.S. So that creates another form of liability. We do think that the entire statute, as we argue in our brief, is extraterritorial, which would remove that as a problem in any event. But we think that we can reach them in both prongs for extraterritorial liability.
But if it doesn't pass, if it's not extraterritorial under prong one, then your reading of prong two would make it extraterritorial in any case where there was a venture.
Because of 1589B, yes, which is explicit. I have 1 minute left for my rebuttal. I think I should stop, or will the
Well,
court grant me additional time?
On the venture question, how do you distinguish Apple?
Thank you.
This feels like pretty similar.
Well, as you well know, Apple has multiple prongs for how you can show participation in a venture. You can show a common purpose, you can share profits and risks, you can show control, or a direct and continuous relationship. Any one of those will suffice. And the word "or" does indicate that. We think we satisfy all of the factors, and I can quickly run through the first one, which is a direct and continuous relationship. We have multiple allegations showing the simple fact of the years of KCC and Ansell using Brightway as a direct supplier. That's easy, but just briefly, paragraphs 1, 29, 30, 48, 69, 58, 101, 102, and 107 show that.
I get that you allege how long this relationship went on. I'm just trying to understand. I did not read Apple as sort of saying it's just a question of time. As long as if you have the type of contractual relationship, the buyer-seller relationship that was going on in Apple, you have that, and you don't, and you just have to have it a certain amount of time. And then I mean, that's what you've alleged is how long, but I don't understanding the relevance of that.
Sure. Well, I think the actual wording of Apple was a direct and continuous relationship. And
continuous.
Direct and continuous. That's a quote. But in this case, I acknowledge we could argue that that's enough. But I acknowledge that some other courts have said, well, you need a little something more, like to show that they had skin in the game or they were participants in some way other than just simply across the years buying the product. And we have that here. Paragraph 103, I will quote, KCC provided Brightway with a significant amount of Brightway's machinery and molds used in manufacturing latex gloves. Also, at one point, KCC owned one of Brightway's factories and sold it to them at a great discount to allow them to continue to
That's what I'm
produce.
trying to understand. So if I've got the history right, Kimberly Clark was at one point operating in Malaysia and then decided to leave. Is that when they sort of sold the factory Brightway?
My understanding from our pleadings is that KCC owned a factory for a while and Brightway was using it, and then it sold it to them at a discount.
When Kimberly Clark left the
Yes,
country.
yes.
That was just so it wasn't like they, from their long distance relationship in the United States as a buyer or seller, that they said, oh, you need a factory, let's buy a whole new factory for you. It's that they were leaving the country, they were selling
And they wanted
whatever their factory was, and they sold it to Brightway.
and gave them a bunch of equipment and materials to make sure that they could boost Brightway's.
They gave new stuff, or was it what was left in the factory?
Well, that we don't know. We know that they gave them a bunch of equipment. And that's my point here about that issue, that paragraph
Well,
one.
I guess I can imagine it being different, that if, in addition to being a buyer or seller, they were sort of sending in all kinds of equipment on an ongoing basis. But I'm trying to understand what your complaint alleges, because it seems to me it's equally fairly read as, if not more fairly read as, Malaysia, Kimberly Clark had its factory in Malaysia, decided to leave the country, and it sold what it was leaving behind to Brightway, or to the highest bidder, which happened to be Brightway.
Well, they were partnered with Brightway in other factories before that, but a reasonable inference is that they gave them this equipment and they gave them materials and they sold them a cheap factory in order to continue to boost and build Brightway's business. But the error here is that the district
They had
court,
to sell it to somebody.
well, they chose their venture partner to boost them, not anyone
Well,
else.
that's, I mean, I understand why you're using that language, but I'm not sure. We got
Well,
to
that's-
show that.
That's the allegation.
Just evidence, like the selling of the machinery, isn't that just further evidence of a commercial relationship, an ordinary commercial relationship? It doesn't show that they were participating in a venture to benefit from forced labor.
Well, they knew about the forced labor at the time, and it shows that they wanted to help Brightway. And the legal error here is that the district court not only didn't take our allegation as true and give us the benefit of reasonable inferences, at page 1, At page 88 of the joint appendix, the district court dismissed that allegation and said that they provided, quote, off-the-shelf materials and machinery. That degraded the allegation. It didn't give us the
Explain why
benefit.
it's a reasonable inference that this, giving molds and machinery leads to an inference of participation in venture for forced labor.
We have to show something more than a long-term and continuous relationship. So what we have shown is that KCC, much like in Salesforce, which provided direct assistance to the business that they were working with there, and here,
But in Salesforce, they provided targeted help to assist them in their forced labor and trafficking advertisements.
well, here, again, we have allegations and well briefed that KCC and Ansel knew or should have known about the forced labor and trafficking when they were doing business in a long-term and continuous relationship. And instead of giving it to somebody else or giving somebody else a deal, they sold this equipment or they gave the equipment and gave a good deal on the factory to build and boost this very business that they knew was producing cheap gloves because it was using forced labor and trafficked labor. And then in paragraphs 59 and 101, we have Ansel providing assistance to Brightway by helping them with their remediation plans in order to try to get from behind the withhold release order that CBP imposed to keep them in business because they were also their long-term business partner in a venture.
But you have, so in Salesforce, the provision of something beyond just buyer sell relationship was itself on a continuous basis. Right? The computer.
Yes.
Right. Okay. But what you allege is a sort of one-off, probably sold them the factory when they left the country and may well have sold them the machinery and molds when they left the country otherwise. But you allege that it happened. They provided it to them. You don't say they were every year sending them new machinery and new molds.
Well, shortly after this, the WRO occurred, and they then began trying to help Brightway to prepare remediation plans and also to be able to sell back in the United States. So that became their form of assistance, which obviously assumes that there was forced labor and trafficking. The WRO occurred.
I'm not sure that just doesn't mean if you want to stay in business with us, you've got to clean up your act here.
Well, they were directly helping them. And if it was a mere, by doing remediation plans, by showing them how to do
Remediation
it.
plan, what do you mean?
Well, in their own reporting in paragraph 59 and 101, Ansel said to the WRO, to the CBP, that don't worry, we're helping with the remediation plans. We're going to get them
I just
back
don't know
up
what
to
that
speed.
means. I don't know anything setting standards for them.
Better forms of enforcement, better forms of monitoring so that there would not be forced labor and trafficking in the future. And if they were just mere purchasers of these gloves from Brightway, they could have gone to anybody else.
Does your complaint allege? I thought your complaint alleged that the forced labor and trafficking at issue here sort of ended at the time of the WRO. Am I wrong? As to these plaintiffs?
As to the plaintiffs, yes.
So what happened after that?
The plaintiffs?
No, what all the stuff about remediation is something that postdates
Right. That's
the
just
plaintiffs
that.
and their asserted injuries. And so
That's just evidence, Your Honor, that they had more than a mere buyer-seller relationship. They were working with Brightway to get them back online so they could continue doing business with them. If they were mere purchasers and didn't care who they bought their gloves from, they could have gone down the street to XYZ factory instead. But they stuck with Brightway because they had a long-term relationship with them and they were in a venture together.
okay, that relationship is a buyer-seller relationship, long-term buyer-seller relationship.
With the kind of assistance that Salesforce pointed to show that it was more than that. If it was not more than that, they could have gone anywhere else and bought gloves from anybody else. They didn't.
One or two questions on unjust enrichment. I recall you handled the case in the Ninth Circuit against Walmart, Doe versus Walmart.
I did, Your Honor.
So the unjust enrichment claim in that case seems similar to the one here. Do you think in order to rule in our favor, in your favor, would we have to conclude that the Ninth Circuit was misunderstood the law of unjust enrichment, or can you distinguish it?
Well, I think the main difference is that here, with the Walmart case, we had a number of different settings. Here, we're focused on one factory where there's no doubt at all that across the long-term relationship with Ansel and KCC, that they benefited from this cheap labor cheap gloves coming from the Brightway factory because of forced labor and trafficking. I think that direct relationship, the ongoing benefiting from it, is different than Walmart, which was really more of a one-off situation.
Suppose I hypothetically think that there's no participation in a venture here. Would that change your answer?
No, we specifically do not require that there be a venture. That doesn't mean that if there's not a venture because it was just a long-term relationship where they were buying the gloves and getting them cheap, that would be one thing. But it would not mean that they're not unjustly enriched if they are receiving the benefit of those cheap gloves that are cheap because of forced labor and trafficking of our plaintiffs and others similarly situated.
Okay, thank you.
Was the Ninth Circuit interpreting DC law?
No, it was not. I was going to add that. Thank you. We do cite DC cases for the unjust enrichment elements.
What's your best case, DC or otherwise, for applying unjust enrichment law in a context where the benefit flows from seller to a buyer to a downstream buyer?
Thank you, Your Honor.
Things that at least superficially look like market transactions.
Can I give you that case when I stand back up, assuming you're going to give me 1 minute or more for a rebuttal?
Sure.
How much time could I have for rebuttal, please?
Well, we'll set that up. So is there anything more you want to say in response to the question now, or you just want to answer it on rebuttal?
No, I have good cases. I want to just go
Okay.
get them, and I'll instead of wasting your time now. Thank you.
That's right. Any other questions?
Maybe when you stand up, you can also say something about choice of law and why DC law is the correct law to apply here.
Is that disputed in this case?
No.
At this stage?
Yeah, that would be my short answer. It's not disputed, and DC is where we filed the case, and the defendants have not challenged jurisdiction or venue, and that's where the case is cited.
And are there cases in DC holding that DC common law claims apply extraterritorially?
There's no challenge on that basis either, Your Honor. And they do. The common law, the rule of the presumption against extraterritorial jurisdiction has not been applied to DC, quote, state law, and defendants have not raised that here.
Well, is the unjust enrichment extraterritorial, or put aside your venture theory? I had thought it was simply benefiting from, domestic benefit, much like your 1589B argument.
No, that is correct. But just in the abstract, I don't think there's an issue of whether these laws apply extraterritorially.
There might be issues about state common law applying extraterritorially. All right. Thank you very much. We will give you some time for rebuttal.
Thank you.
Morning, Your Honor. May it please the court. I'd like to come back to the extraterritoriality issue, which was a focus of a number of the court's questions. But if I could start with the question of participation in a venture, and Judge Millett, you asked, that doesn't this seem very similar to the Apple case? And it does. The plaintiffs had an opportunity after Apple to amend their complaint to try to meet the standard that this court set in Apple. What they came up with was 8 paragraphs, at paragraphs 99 to 107. Mostly, they recite several times that this is a buyer-supplier relationship. What Apple held is that a buyer-supplier relationship is not enough. Plaintiffs say you had leverage. You could have withheld your purchases. You had audit rights. Apple addressed those things. It says you can extort your supplier. That's not enough. You can have audit rights. That's not enough. For Ansel, which is one of the defendants here, That's it. It's just the buyer-supplier relationship. With Kimberly Clark, all they add is this incredibly cursory allegation at paragraph
Well, cursory's
103.
okay at this early stage.
Cursory is okay, but it sort of only gets you as far as you're able to allege. So the question is, what is a plausible inference that you can draw from the allegation that, for example, some machinery was provided, even a significant, I don't want to, shortchange the allegation, a significant amount of machinery was provided. How much exactly? How did that help Brightway? Was that integral to its business? The plaintiffs have been shorthanding this idea.
They had alleged the provision of, I assume there was only one factory or more than one?
Your Honor, I can only go based on the allegation. They said at one time, Kimberly Clark sold a factory.
Okay. But are the machinery and molds provided on an ongoing basis, updated equipment?
Your Honor, again, this is, I think, where we get into the issue of the cursory nature of the allegation. I don't know.
Well, what's a fair inference from the allegation?
A fair inference is that at some point, significant amounts of machinery were provided. I think even if that was ongoing and in a continuous way, I think the only natural inference I can think of is that, as Judge Rouse suggested earlier, this is what happens in buyer-supplier relationships. It's one thing to say, I want a bunch of
It's not what was
gloves.
going on in Apple. It's a big difference from Apple. No, Apple wasn't providing anybody machinery, let alone factories.
No, Your Honor. So I think the question is, what Apple said is you need more than a buyer supplier.
Computer services continually, you're in trouble under Salesforce. If you provide equipment continually, that's okay. That would seem an odd distinction.
Your Honor, I don't read Salesforce as saying if you continually provide computer services, period, then you're participating in a venture. Salesforce had incredibly detailed allegations about the growth.
Is that the what makes you think Salesforce is the bare minimum as opposed to an easy case?
Your Honor, I'm not suggesting that it's a bare minimum. I'm following what the court said in Apple, which is this isn't the type, the plaintiffs have said, if you have a direct and continuous relationship, boom, you're a participant in a venture. I don't think that's what Apple said. It said, if you have the type of relationship that was at issue in Salesforce. And so I'm not saying that Salesforce is the bare minimum, but when you look at what it was about at its core, it was about Salesforce involving itself in the operations of a sex trafficking website.
If you are constantly providing the put aside the factory, the equipment, updating and sending new stuff every year, plus the buyer-seller relationship, your position is that that's what normal buyer-seller contracts do?
Well, your first, and I take that maybe to be a hypothetical because the constantly point is not pled, but if that.
That was the question that I asked you.
Yes.
And I thought you were saying not good enough under Apple. And that's what that is the very
Right.
question I'm asking you.
Sure. And I think it would depend on all of the facts that were alleged. And the reason I say that is because, I take the North Star of Apple to be that the plain ordinary meaning of participation in a venture is that you are in a shared enterprise. You are sharing opportunities for risk, for profit, and you are sharing in the risk of loss. So I think the question is
Investing, they were investing money in this, apart from their buyer-seller contract. That's at some level, that's a providing, but put that aside. They also were investing money every year in the company, whether in the form of just giving them capital or giving them equipment or giving them high-tech computer services. I'm just curious as to why you are resisting that would be different.
I think it might be with enough facts alleged.
I'm telling you the facts.
Okay.
And it seems as alleged and that whether that could be good enough for a complaint. And that is, if they said on an annual basis, they are sending in capital investments, equipment, physical manufacturing equipment, high-tech computer services.
I think it would depend. Is it only to use for the particular products that Kimberly Clark wants? In which case,
They're
sounds.
not making factory. As far as we know, that's all they do.
Well, is it because Kimberly Clark wants their gloves made to a particular specification? And so the same way, for example, if you had a T-shirt factory.
So you think that's what matters?
I think it's relevant. I think it's relevant to sharing of risk.
Someone could be doing this, but it's not specialized. It doesn't have a Kimberly Clark embossment on it or anything. But someone could be actually sort of co-running this business and throwing money and equipment and technology at it.
Well, Your Honor, I think once we get to, once you're able to plausibly infer that you are co-running the business, then I think
I'm that's my label on what this is when you are providing all of the, or lots of, let's say a significant percentage of the equipment. Assuming they're the high-tech services and a significant capital contribution. I don't know why you're resisting that.
Your Honor, I guess I guess the question is just whether it's plausible at that point to infer you're running together.
At risk, be at risk. I mean, that's a lot of sunk costs if this business goes belly up.
Sure. Well, I think
it's a WRO against them. That's a lot of stuff you've invested there that's gone. That's not a venture.
I think I would say that I will acknowledge that at some point, if you have enough in there and you have enough riding on this and your profits, I guess I'm not sure, but it's not the one sentence, a significant amount of machinery. I think, these things get done on a case-to-case basis. I think Salesforce is instructive when you talk about.
If they've said a significant amount of machinery and it's unclear from the complaint whether it was continuous or not, it's just not specified. Do we have to write the opinion and say we infer it wasn't continuous? We infer that against plaintiffs, and so we won't find a venture here?
I think, Your Honor,
but if they did say continuous, then we would infer otherwise?
I don't think continuous is the be all and end all. I think what does it do to the ultimate relation? Is it, I think the question would be, I think what Your Honor asked, that arises to the level of basically operating the business together. I think that could be a workable standard. And the question is,
sort of the conclusion that comes from being a venture is that you both got skin in the game. So I don't think you can say that that's the test. I think that's the conclusion. And so I'm trying to understand what you think the test is in an opinion where we do have different allegation than Apple, what it should be for a venture in this context.
I think, is the amount of machinery that is being provided so significant that, one, is this
they use significant. They use that word.
They do use the word significant. I think that's a conclusion they put in there in their one sentence allegation. Is it so significant?
It's an adjective describing volume is actually another way to think about it. It's a factual allegation.
Sure, Your Honor. And in Apple, the court referred to, unspecified amounts of purchases. There's sort of. That
was just buyer, seller. I think there was even another in-between person there. That's not what was going on here.
Sure, Your Honor. I think it would look to a couple of things. Are there allegations that this is something that ordinary buyers and sellers don't do? That's not alleged.
No, I've never run businesses. I didn't know that ordinary buyer sellers, arm's length relationships a la Apple, are donating, giving significant amounts of machinery and molds to the manufacturer. Am I wrong? Is that normal?
Well, Your Honor,
does Kimberly Clark do that, or Ansel? You said Ansel didn't do it. So it doesn't seem like it's part of their business. Does Kimberly Clark? I mean, one thing you should know is whether your client does that routinely to say domestic manufacturers.
As I understand it, it is normal to have a sort of bailment arrangement where someone is making products for you, and you provide a particular piece of equipment to use to make that product to a particular specification. It's like if you want to mass produce T-shirts
on this equipment.
We're now getting past beyond the complaint, but Your Honor asked, if my understanding as to whether this is normal. My understanding is that in these business operations it is, but there's certainly no allegation that it's not. Well, Apple is a different industry. That's sort of that mass production of commodity. I'm not here to say that Apple has exactly the same facts. I certainly wouldn't say that. What it does is have the test.
So were the molds? Well, I know, but that's why I'm struggling with trying to apply that test to different facts. That's what this case is about on the venture issue. Were the molds, were they Kimberly Clark specific then? Did it have a little Kimberly Clark design on it? Is that why they gave them, I don't know how much of a mold you need for a glove. If they had their own specific gloves, it sounds like then what is maybe normal is you give them equipment for manufacturing your gloves, but not Ansel's gloves or anyone else's gloves. Is that what is meant by the machinery and molds?
Your Honor, talking about the allegation, the short answer is I don't know from the one sentence what exactly they think was provided, what they think that it was used for. We don't know the amount. We don't know the purpose. We don't know is it ordinary or is it not ordinary? And we don't know. Again, I think Salesforce is instructive in the sense of, are you sort of so enmeshed in the business that you are having an effect on the ability for Brightway to run its business? Not just can you fulfill the contract for Kimberly Clark? Is this rising to the level that you are enmeshing yourself in the way that Brightway is running its business? So I think you could have had allegations. So for example, was Kimberly Clark the only customer? Was there a fivefold growth like there was in Salesforce, or even double growth? Did when this factory was sold, or when these machinery was provided?
Clark and Ansel were 2/3 of the purchasers of the gloves from this factory.
I don't think that's been alleged, Your Honor. We know
I thought it was in the record that the only other purchaser was the National Health Service.
the plaintiffs don't allege anything about how many other buyers there were. We know from a press report that was incorporated into the complaint that the National Health Service of the UK was another buyer. Mm-hmm. I don't see anything in that article or in the complaint that says those were the only 3 buyers. It's just more and more and more. And so one thing I was suggesting was, before Kimberly Clark was involved, was Brightway's operation not at scale? And then we also have an allegation that Kimberly Clark and Ansel stopped buying gloves. Did Brightway collapse? What happened? That would have been very, very relevant to understanding what is exactly the nature of this supposed dependency on the factory, on the machinery. There's just so little here. And I do think I completely appreciate, Your Honor, that you want to write the opinion and know exactly where to draw the line.
Be careful, because at some level, these are victims of slavery, forced labor, trafficking. There has to be a line between they've said enough to get past the 12B6 stage, but the other stuff is information that they're not going to know. It's lots of economic injury. Business information is not often shared with your forced employees.
And first of all, I would want to say Kimberly Clark and Ansel take allegations like this very seriously. And the point here is, not should there be any response to these allegations of forced labor and supply chains. Congress has taken a number of steps. You have the system working with the withhold release order here, and immediately, as the plaintiffs allege, Kimberly Clark and Ansel cut off their ties and stopped buying the gloves. The question here is, this is a statute that Congress enacted, and we've got to, give it its faithful interpretation. Congress, at times, I heard Mr. Collingsworth basically describe a form of liability where if you know that something is going on in your supply chain and you buy from that supplier, then you're liable. It would not have been that hard for Congress to write a statute like that. It used a very particular formulation, participation in a venture. So I do think, the court, was right in Apple and should here demand that the plaintiffs really make a showing that this goes beyond a buyer-supplier relationship into something where it looks like it is, as Your Honor well put it, in business together.
The same venture test would apply domestically to a domestic glove manufacturer.
Yes, Your Honor. I think that's the venture test that was applied, that was succeeded in Riccio, succeeded in Salesforce. So I don't think our approach here. We're not suggesting they were wrong.
Okay, but that's back to it succeeded there. Those things seemed like, if anything was a venture, that was. But what we need to understand is, what is the distinguishing line here? And it can't be that you have to have all that much of a show, the same showing. That seemed to be more than enough in those 2 cases.
Yeah, that was certainly enough in those cases. I agree. This case is sort of somewhere in between, say, Salesforce and Apple. I think it is a lot closer to Apple than it is to Salesforce. And of course, case by case, judging, there will be distinctions. You have to decide, which side of the line it falls on. But I will say, the question of, under Twombly and Iqbal, it is the burden of the plaintiffs to allege enough. And I think these 2 sentences about some machinery in a factory one time is not enough to say, under the standard, the plain meaning standard this court adopted in Apple, that's not enough to say you are fundamentally in business together, you're in it together, your risks and your profits were rising and falling together. I see I'm out of time. I was hoping to address extraterritoriality, but I'll make the court's.
I just have a question or two on unjust enrichment, which I think is a tougher claim for you, because there does seem to be some authority for the proposition that if a plaintiff confers a benefit on a defendant and that gets passed down a chain, the plaintiff can sue an indirect beneficiary.
Sure, Your Honor. And I'm
So
interested.
suppose for purposes of this question, suppose I think your colleague on the other side is right that knowledge was adequately pleaded. So you have Brightway being unjustly enriched through this forced labor, and then the defendants here knowingly taking advantage of that and being, they say, unjustly enriched through buying these products at a discount, reflecting the forced labor. I mean, there's a lot of factual assumptions in that. There might be hard questions about how the markets work and stuff, but I didn't see an obvious legal roadblock in unjust enrichment law to prevent them from trying to make an indirect unjust enrichment claim. So help me out with that.
Sure, Your Honor. And so I think the way I would think about this is not direct versus direct, but is there
Not direct versus
indirect?
Okay.
It's was there conferral of a benefit from the plaintiff to the defendant. So I'm interested to hear what case Mr. Collingsworth comes up with as his best case. I suspect it will be a case that's about money. A pays a premium to B. B kicks it over to C. A is able to sue C to recover that premium that was paid. B and C are in a scheme together. They manage to bill A out of some money. B is the one who initially collects it, gives C their share. Then A sues C. We're not talking.
Easier case if B and C are in the scheme.
Much easier case if they're in the scheme, even if you allow.
Even if they're not in the scheme. I mean, I was really trying to think like, what is the right legal doctrine to decide how far down the chain you can go? And like one possibility might be, is C a bona fide purchaser? And that would seem to turn on, did C have notice of that it was acquiring something illicit? And on this hypothetical, I'm assuming notice, I'm assuming knowledge.
Sure, Your Honor. So I guess, so let me suggest maybe another way of thinking about it, which is to distinguish the money cases.
Why is that way of thinking about it wrong too?
Sure. So I think, let's think about what is the benefit that's conferred. In these cases where you're sort of following the money down the stream, it's money. You can trace, A paid $1,000 and maybe it stopped with B or maybe it went to C.
It's a discount reflecting unreasonable cheapness of labor because of the horrible conditions.
Yes, but I think it becomes different when you're asking about the way that unjust enrichment doctrine is phrased is in terms of conferral of a benefit. So the question is, what did the plaintiffs here confer on anyone? What they conferred on Brightway was their labor. And they allege that they did that under horrible conditions, and we absolutely are condemning that. Brightway benefited from the conferral of labor by the plaintiffs. So the question is, if the plaintiffs had given $1,000 to Brightway, and then Brightway shared some of that with Kimberly, Clark, and Ansel, maybe we're talking something else. I don't think it quite works to say the labor was then conferred from Brightway. Brightway received the labor, and then they sort of conferred down the chain that labor onto Kimberly, Clark.
Yeah.
Well, I think then you get in.
I'm not an economist, but it doesn't seem unreasonable to think of it that way. And I mean, unless, I'm not sure if it's the supply curve or the demand curve, but unless there's complete price inelasticity, some of that is going to get passed on, right?
I think that's right. And I think
Some of that value will be passed on to the indirect purchaser of the labor.
And I'm just not familiar with any unjust enrichment case, certainly not one that the plaintiffs have cited that goes that far.
I'm not either. I can't think of the legal magic bullet to say that there can't be one. That's what I'm struggling with.
Because I think, now we're very much in the realm of common lawmaking. And I think, we look at, and I think the fact that what we're now getting into these complicated econometrics and things like that is a pretty good reason, sitting in diversity, I guess this would be supplemental jurisdiction. I think the court, if it reaches that question, would have to ask, is that really, a step that the common law is supposed to go when adjudicating that claim really would require a common law court to ask these questions about inelasticity of markets and prices and supply and demand curves. It gets really complicated. And I think it gets into questions. We haven't at this stage raised extraterritoriality issues. I think those do loom here. And the other thing that I would say is that we have a statute. Congress, passed a statute that says we don't think there should be a sort of general abstract unjust enrichment concept for supply chains where lots of people down the chain might be buying something that could be tainted at the start. I think the question is, I think a reasonable question for a common law court to ask, should we extend the common law to do all of these complicated economic things in an area, that gets into questions of foreign relations, and, Congress has taken a different approach and a narrower approach. I think that there's a lot of reason for caution, before extending a common law claim into something that really hasn't been seen in the common law before.
Well, do you know if the DC Court of Appeals follows the restatement?
I think it does. And I don't.
Restatement third says, if the claimant renders to a third person a contractual performance for which the claimant does not receive the promised compensation, and the effect of the claimant's uncompensated performance is to confer a benefit on the defendant, the claimant is entitled to restitution from the defendant as necessary to prevent unjust enrichment. That sounds like exactly this case.
I
The
guess
restatement is restating common law.
right.
Now, whether those factors are met, whether the enrichment was unjust or not, I don't think that knowledge, innocent buyer, those things. So, but it seems to me, at least the principle of law that Judge Katsas has been asking about, that I agree with you. I think the DC Court of Appeals does follow the restatement. The restatement articulates in the exact terms of this situation an underpayment to the laborer that allows for a cheaper product to the purchaser, allows for a claim of unjust enrichment against the purchaser.
Sure. Well, Your Honor, I may have missed part of the quote as you're reading. I didn't hear anything specific to a laborer. Maybe I missed that.
It's a contractual performance for which they're not compensated.
Sure. And that could be, the sale of land and in any number of things. I guess what I'm saying is just.
But they don't limit it to that.
Sure. And so I think, a restatement is a good place to start. And then one.
Well, you were just saying you weren't aware of any common law principle. And it just seems to me that extent the restatements saying that, making that point in a number of different ways.
Sure. You're
It's certainly something one would need to at least take into account. I mean, the district court's ruling here was simply a flat can't ever happen. And if that's incorrect, then that's an error.
We're on it.
Without an analysis of whether DC Court of Appeals follows the restatement, and then whether the restatement articulations cover the situation.
Sure.
You think there might be a difference between wages and land?
We're on. I think the principle. I think common law adjudicating is all about how these things apply to different sets of facts, and I think you want to. I guess I can think of a lot of situations where there is labor is provided. For example, Fair Labor Standards Act. Someone doesn't pay overtime. The chicken farmer doesn't pay their workers overtime. You could have an FLSA claim against the producer. Could you have an unjust enrichment claim against giant supermarket and say the laborer conferred a benefit on the poultry manufacturer and they passed that along in the form of cheaper prices at the grocery store?
About it?
I suppose, Your Honor, that just happened.
I'm just asking you.
Yeah.
I'm not saying that's what happened here. If they knew about it, the two of them were, all right, we won't pay them that so that your gloves will be cheaper and then you'll have a higher profit margin when you sell them to hospitals and doctors' offices. If there were such knowledge of that sort of passing along a financial benefit, knowledge and intent. What's the objection?
I think the objection is just how complicated it would be to
Complicated, what's
trace
complicated?
benefits.
Tort law does intent all the time and knowledge all the time. It also deals with innocent owners. It deals with bona fide purchasers and not bona fide purchasers. I don't know, it's so complicated. This is what happens in the law all the time. And you want to make some global rule that even if someone intentionally, knowingly engaged in this contractual relationship where you cheat them and that will let you give me a lower price and I am untouchable, and the law can't handle that?
I think the law can handle, I think, some version of what Your Honor just said, starts to look like a scheme. And that, starts to look like these cases where it's, the premiums are collected and you're kind of sort of all agreeing to bilk someone.
Adding more factors and makes it more workable?
I think
Scheme now?
no, Your Honor, I think
I mean, your case is a little more complicated because you talked about a statute, so there are all kinds of issues about common
Right.
law related on that. But let's just assume instead it was a common law problem. Underpaid this person, grossly underpaid them.
right. I think it's,
That's what the law promised them.
I'm not disputing the courts can't handle knowledge and intent. I'm talking about when you start tracing, the value of labor through a supply chain, and does it stop?
Adjustment enrichment has been around for a very long time, as have labor supply chains. And it hasn't been a problem. So why is it suddenly a problem now?
Your Honor, I think it hasn't been a problem because I'm not aware of cases like this.
You're talking about the TVPRA. I'm talking about.
No, Your Honor, I'm talking,
Right.
oh, sorry.
No. So I think one is an awful lot of times it's an innocent buyer that cuts it off right then and there. You don't have the knowledge.
I think that, and I guess I'll take the opportunity to say, I think that could be one way out in this case, because we don't think what they allege here is that the audits
They
didn't.
definitely are not alleging. There's no allegation here that suggests that in their view, Kimberly, Clark, and Ansel are innocent purchasers. Allege exactly the opposite.
Well, respectfully, they don't. If you take the complaint as a whole, including what the district court found unchallenged to be materials incorporated by reference, the audits, the third-party audits that were provided to Ansel and Kimberly Clark found there was not forced labor.
Okay, if that's how we might read the complaint differently.
Can I just ask you a question on extraterritoriality? If we are operating under the second prong of RJR Nabisco,
Your Honor.
is there any way for the plaintiffs to allege that the focus of the statute has a permissible domestic effect?
I don't.
What would they have to allege to show that?
Well, Your Honor, what the Supreme Court has said is you look at what is the focus of the statute? What is the object of its solicitude? Who is it trying to protect? I think the obvious thing that this statute is focused on is forced labor, and it's trying to protect, people who are victimized by forced labor and trafficking. So then you would look to where does the conduct relevant to that focus happen? I appreciate the plaintiffs want to say it's the benefit. I have a couple things to say about that.
Doesn't Congress in part say it is the benefit, right? They don't want companies benefiting from participation in a venture that involves forced labor or trafficking.
Sure, Your Honor. And that I agree that is an element of the statute, but that's not the end of the focus analysis. I think Your Honor asked a good question before. Why is the focus the benefit and not the participation? The actual statutory phrase is not knowingly benefit from the forced labor, it's knowingly benefit from participation in a venture that has engaged in the forced labor.
So perhaps plaintiffs here have not alleged enough, but do you think it's possible where the forced labor occurs abroad for there to be liability for a U.S. company domestically?
Your Honor,
Is it possible?
I don't think
That could be like if there was evidence, say, of participation, like if there were venture activities that occurred domestically, would that make it possible to sue a company in the United States?
Your Honor, my position is that the focus of this statute is the forced labor. And so the question is where that came in. I don't think the court necessarily has to reach that question today because, I think you could leave open the question of whether participation in a venture is enough. I think you'd have to wrestle with things like Doe versus Nestle, where the court says, well, it's not enough to have corporate decision-making in the U.S. that causes these harms abroad. I think that might be a complicated issue with that theory. But if you had real significant, perhaps one could say that the focus of this provision is the participation in the venture. And so if you had, a lot of participation activity in the U.S., again, this is not my position. I think the focus is the forced labor, but I could imagine that position and it still wouldn't be good enough for the plaintiffs here.
Are you running away from your other argument that the focus of the cause of action is the injury?
No, Your Honor. I think, the injury is being subject to forced labor. So I think that is maybe just another way of phrasing, what I was trying to say, or at least I hope so.
Oh, you said the focus was being a victim of forced labor.
Yes, that's right.
So if the focus is on when I say forced labor, so the statutory violation,
Yes.
forced labor,
Mhm.
victimhood, that's what the cause of action is focused on.
I think that's right. That's what, just from top to bottom, that's what everything about this statute is focused on. Who is the object of Congress's solicitude? It says Your Honor quoted this language before, the victim of the violation. So I think, who is the victim? Where were they victimized through forced labor?
That is the exclusive focus of the statute or the primary focus of the statute and under the way we think about that under RJR Nabisco, then there would never be liability for a U.S. company for forced labor that occurred abroad, because the injury and the victimization would always be overseas.
I think that's right. I could imagine, one thing that Congress was very focused on when it passed this law, there's a lot of immigration related provisions. So I can imagine transnational cases where there's sort of trafficking that overlap, that happens, kind of continues from one country, starts in the United States and somewhere else, starts in a different country and comes into the United States. So I think that could be right. But I agree, Your Honor. I think, with this.
Then there would only be liability for U.S. companies where the forced labor occurred domestically.
I think that's the consequence of what the Supreme Court has applied, time and time again, a muscular presumption against extraterritoriality for very good reasons. As Judge Katsas was alluding to before, it is a very big step to go from criminal, a substantive offense that is criminally prosecuted by a United States attorney who is accountable to the executive branch. In some circumstances, by statute, you're supposed to have the express sign off of the Attorney General and the Deputy Attorney General. The Supreme Court said it's a very big step to then turn this over to private plaintiffs, to sue over things that happened in different countries. And so you need.
It goes to the prong one of RJR Nabisco.
Well, it does, Your Honor, but what all
not to whether there could ever be, permissible domestic application of the statute.
No, Your Honor. The only thing I would just add to that is what is because the court at applying this step 2, what it has said a couple of different times, that the presumption would be a craven watchdog indeed if it retreated into its kennel as soon as you had sort of any hint of something domestic. So I think in applying the focus standard and giving it its due, the court is very much focused on making sure that you don't just have you don't just kind of throw out the presumption and the important work that it's doing by being too lax about looking to domestic conduct that you say would meet the focus. So I think that's why, and I guess my broader point here is this is a fundamentally a decision for Congress, and that is something Congress could decide, that it thinks that actually private plaintiffs should be doing these things, and if Congress thinks that that's not the right result, the Supreme Court has told it what to do. Speak more clearly.
Just to be clear, so if you had a company that was in the venture of all ventures with a Brightway, picked their employees, had their own employees on the ground there, gave them all the equipment they need, kinds of contractual connections between them, ongoing. It puts Salesforce to shame, this venture that I'm hypothesizing to you. And we've got the memos from the company here in the US saying, gosh, too bad we're going to have to pay just wages. Wait, how about we outsource it to this company we're going to set up over here? So we are a venture of all ventures. And your position is? We don't think Congress wanted that? You stop that?
My position is.
Is it yes or no? Extraterritoriality does the statute apply to that situation or not?
The civil cause of action does not. That company needs a very good white collar lawyer because they are in a lot of trouble under criminal laws. They can be enforced. They can
Maybe
be
not.
subject.
See whom, it's a lot. Our prosecutors have a lot, attorney generals have a lot on their plates for prosecutions. So maybe not.
Right.
But Congress didn't mean to stop that through civil cause of action, only through criminal enforcement. That's how you read the statute.
I think Congress did not speak clearly enough to overcome the presumption against extraterritoriality to reach that result.
You did that because you said the way you were defining focus was solicitude. Who does Congress have solicitude for? He said, victims. I feel bad for victims. Why isn't the focus inquiry? What did Congress want to stop? What did it want to use every tool at its disposal to stop? Well, thankfully, we're at a point where maybe what they wanted to stop was slavery, trafficking, sex trafficking, peonage. And those companies in the United States, President of the United States, nationals of the United States, who knowingly engage in a venture and profit from this process. And you want to say, no, that's not what Congress, it was just one, we feel bad for victims in the United States. Now, if I look at the statute as being the focus being make this stop, we are not going to, the United States is not going to be a part of this system, and we are using criminal and civil tools at our disposal. Does that change the extraterritoriality analysis? Or not the extraterritorial, the prong two analysis of RJR? If you look at it as cut it off.
Right. I guess the question is, what is the it? If the it is the forced labor,
slavery, sex trafficking, all of the criminal offenses. It's pretty clear what Congress wants to stop. It's a lot for Congress to say we're going to apply this overseas. It's a lot to do. And to say we want it to stop, and then to say at numerous points in the statute, and you can't wash your hands of it in this country. You can't outsource it. That will be stopped too, and we will use both the government's own enforcement capacities and private enforcement, because that is a very effective way of making conduct that is reprehensible to the United States stop.
Your Honor.
If that's what the statute does, I think we're right in the core of the gravamen. Tell me why I'm wrong.
Well, I would say I think the question is focus, not gravamen. When I was using the phrase object of solicitude.
Focus. Stop this.
Yeah.
This conduct.
In the
and do not benefit from it in this country.
Your Honor, I think there's two different parts to it. There's this conduct, and then there's the benefiting from it. I am totally with you. Congress thought this was absolutely atrocious conduct, and I agree with them. Kimberly, Clark, and Ansel agree with that. Congress wanted to stop this horrible forced labor, peonage, trafficking, slavery. So the Supreme Court says, if that is the focus, where the conduct that is relevant to that focus happened, and it happened in Malaysia and Bangladesh. Where I disagree is to say also the focus in that core sense where what the Supreme Court has told us is this is not a
core sense is there's two. There's another focal point, and that is nationals of the United States that knowingly benefit by participation in a venture that's doing this. That's a focus too. They added it in multiple locations. That is a focus too. Is stopping not just Malaysia from having companies that do it, but having companies here knowingly financially benefit from it. I don't know how you can say that is not part of the focus.
It's certainly part of the statute. And
it's not, but it's not part of Congress's focus.
I would say when you look at the statute as a whole, when Congress added this in 2008, it added the knowing beneficiary liability to 1595. At the exact same time, it added 1596 and extended extraterritorial criminal prosecution. So I think when you look at the focus of what Congress is doing, you put aside the step one, step two, just look at a whole at this statute. At the very same time that Congress was expanding civil civil liability to
We don't have to
beneficiaries.
do the solicitude test and look at the focus. We have to look and see whether, so what your test is, we have to look and see whether this, and thou shall not benefit from it financially, knowingly in this country. We have to say that wasn't part of the focus.
Your Honor, I think what I'm applying is the Supreme Court standard for how you
Answer my
determine.
question, can you please? So your analysis says that was not part of Congress's focus.
The focus of the statute is the forced
No,
labor,
but-
is my position.
Okay. All right. Not all hands on deck to get rid of it.
Your Honor, a lot of hands on deck, criminal prosecution, withhold release orders, a lot of the force of the federal government
But
coming
not
to
all
bear on
hands
this.
deck.
Not the sort of private right of action that the Supreme Court has said causes a risk of international friction, and that Congress needs to be clear if that's what it's going to
This
do.
friction is nothing like the friction the Supreme Court has talked about. The friction they've talked about is one, treble damages, which aren't allowed here. Friction is, well, other countries might have their own way of regulating these things, which were predominantly economic activities. In RJ, Nabisco, Morrison, Epigram.
I disagree.
We think Congress here was worried. I mean, it's not, first of all, foreign affairs is something we defer to the political branches. Congress passed this, president signed it. Congress strengthened it, president signed it. And so when we start emptying it, we're stepping out of our role. When we start emptying it of the force that we can tell that Congress, or that we discern Congress intended, that's not our role either. And if we assume there's no solicitude on Congress's part, an assumption that it's okay for other countries to make a different choice about forced labor, slavery, sex trafficking, that's not an area, unlike the other cases Supreme Court has talked about, where they want to be solicitude of other countries. If they wanted to be solicitous of other countries, they would not be authorizing the federal government to go into those other countries and start prosecuting people.
Well, Your Honor, they authorized the federal government
Really?
to do that, with particular checks on prosecutorial discretion involving the express sign off of the Attorney General and the Deputy Attorney General.
They're always responsible for criminal prosecutions by the United States. Yes, that's a big deal. It sure doesn't suggest solicitude for other countries making different regulatory judgments about whether to come down hard on these practices, unlike the other cases before the Supreme Court.
Sure, Your Honor. I think all I will say is I don't think the Supreme Court, when it talks about international friction, it is not just disagreement about, is this bad conduct or not.
Spent a lot of time on treble damages.
Right. I think we'll have.
Talked about these are regulatory, the tension was, well, other countries are regulating this conduct, but they have different line drawing, different ways of bringing that to bear. But no one's arguing here that that's what's being stepped on.
Your Honor, I think there's also questions of capacity building and bringing things into the United States as opposed to abroad. When you look top to bottom at this statute, there is federal foreign assistance to countries to help them investigate and prosecute. There's sticks. There's penalties on countries that don't conduct proper actions. There's a lot of foreign relations in this statute. And again, I think ultimately it just comes down to a presumption. Congress said, it may be right that the right answer that the political branches would give is that we want private rights of action here, and we want people enforcing this, through a private right of action. That's something that Congress needs to speak clearly about. That's our only point.
More questions? All right. Thank you very much, Council. We kept you awfully long time. Thank you.
Thank you, Your Honor.
Okay, we'll give you 3 minutes, Mr. Collinsworth.
Thank you, Your Honor. Where to begin? I would just remind the court again that in terms of the scope of the statute, I read to you the quote of the sponsors of the bill, and they certainly thought that they were going to stop forced labor and trafficking in the global economy with the amendments to the TVPRA. In that same Nestle case, Justice Thomas, who wrote the opinion, was contrasting the Alien Tort Statute with the TVPRA in terms of its scope And he said, quote, "In 2008, Congress created the present right of action in the TVPRA, allowing plaintiffs to sue defendants who are involved indirectly with slavery." And that's Nestle versus Doe 593 U.S. at 638. All of the legislative history indicates a broad plan to have a tool that would actually stop forced labor and trafficking. And with the 3 minutes, I cannot go into the details of our substantive argument on extraterritorial jurisdiction. But I will note that in our opening brief at 10 to 27, our reply brief at 5 to 14, and the entire amicus brief filed by the legal scholars, we think that 1596 extended these extraterritorial predicates and that caused 1595's exact same extraterritorial predicates to apply extraterritorially. And if they don't, then certainly 1589B applies here both to extend it extraterritorially because 1596 extends all offenses, or 1589B makes the focus of just that, forced labor, benefiting from forced labor, domestic.
The damages you seek, are they the same for the forced labor and trafficking?
We did not break out the different categories of damages, just that they were damaged.
Forced labor claim could allow for full compensation of your clients.
Yes, Your Honor, certainly. I was asked about unjust enrichment. Let me say that the two best cases we cited page 50 of our opening brief, the JSC Transmash Holding case, 70F sub 3rd.
And that one in Campbell?
And Campbell, yes.
Okay, I have those.
Yes, both of them deal with indirect liability, the kinds of issues we're discussing here. And we certainly also discuss Section 47 of the restatement, which Judge Millett pointed out as well. That applies directly here. Now, let me just say that, first of all, we have many allegations showing or alleging that Kimberly Clark and Ansel are benefiting from the forced labor and trafficking by cheap gloves. That's the whole point. Forced laborers don't get paid, so the price of gloves goes down. That's paragraphs 47, 108, and 109. We also show.
1 second, do you have any questions? Okay, I think you are over your rebuttal time, and we're aware of what your briefs already say you have. I promise you we've read it.
Thank you for your attention, Your Honors. I appreciate it.
Okay, thank you. The case is submitted.
You have to keep standing.
Yeah, I always do.
She used to do that.
Case number 24-1193 et al. Chamber of Commerce of the United States of America et al. Petitioners versus Environmental Protection Agency and Liam Zeldin in his official capacity as Administrator, United States Environmental Protection Agency. Mr. Lin for the petitioners, Mr. Walters for the respondents, Mr. Kalmus-Katz for the respondent.
Good morning.
Good morning. It may please the court. Albert Lin on behalf of petitioners. There are several independent errors that require vacature of EPA's rule designating PFOA and PFOS as hazardous substances under CERCLA. But I'd like to start with notice and comment, as we believe that is the most glaring error and would, standing alone, require vacature. Under this court's longstanding critical information precedent, it is a violation of the APA's notice and comment requirement when an agency introduces in the final rule new methodologies, conclusions, or data that does more than simply support prior disclosed data. EPA ran afoul of those precedents here when it introduced with its final rule a brand new totality of the circumstances analysis supported by a new 300-page regulatory impact analysis that at J 387 to 389 weighed 29 different impact categories in comparing the advantages and disadvantages of the rule.
What's the study that you think EPA should have disclosed in the notice?
It's not a study per se.
You're saying they didn't disclose the RIA. Like, yeah, sure, the RIA is the product of the rulemaking.
Of course.
The rulemaking will never come to an end if the end product has to be disclosed at the outset.
There are 6 different methodologies, assumptions, and quantitative analyses that they undertook. So I don't think it has to be a study per se. I think if you look at the owner-operator case from this court, it talks about a methodology that was used. It's not a specific study. So I could go through all 6 of them, and I'll just start with just a couple. I mean, the first is the EPA concluded that it would entirely ignore costs at federal Superfund sites. And this, it said
But
I think.
But they told you on the front end of the rulemaking, there is a unitary question, designate or no designate. It's an on-off switch. They proposed to do it, and they invited comments about whether costs should be considered, what costs should be considered. All of those questions they teed up, and they didn't. This is not a case where they have studies in their files that they're hiding. They quite reasonably expressed uncertainty, right? How in the world can you precisely quantify all this stuff? And they solicited input, and you all had every opportunity in the world to comment.
Your Honor, I think that's the difference between the logical outgrowth doctrine and the critical information doctrine. I think the Chamber of Commerce versus SEC case, 2006 of this court, makes that clear, where it says that, I mean, there was what this court called a bare request for comment on a potential change to the cost benefit analysis. And the court said that wasn't enough because the agency, that might be enough for logical outgrowth. Windows Covering Manufacturers case from 2023 distinguishes between the two. It says there was no logical outgrowth problem there, but there was a critical information problem. And here, yes, they asked for, comment on, do we have to consider costs, and tell us what costs you think we need to consider. But it then introduced whole assumptions and about things that it was going to consider costs, conceptualizations of what is a cost and what is a benefit that were never disclosed. I think the federal, again, I have 6 different ones, but I'll start with the federal one. In the notice of proposed rulemaking and the economic assessment, where they talk about how there's a lot of uncertainty and they say, tell us something about costs, they highlighted the Department of Defense's estimates for federal costs and cleanups and said, hey, look at this. Here's something that might be relevant in the cost analysis, although they said we're precluded from considering costs. And then they turned around in the final rule and said, we're not going to consider federal costs at all. We're going to completely ignore what happens at federal sites, and we're only going to look at things that happen at non-federal sites. That is call it a methodology, or call it an assumption, or call it a conceptualization, but it is an underlying principle.
I get that. And you have some precedent on your side, no question about it. Owners and operators is a good case for you. Just struggling. I mean, if we apply this doctrine as broadly as you're asking us to, I mean, we'll really get a big Vermont Yankee problem. And there's a big problem that we're effectively requiring formal rulemaking as opposed to informal rulemaking. You have to put everything into the record. That's formal rule, into a record. That's formal rulemaking.
A couple answers to that, Your Honor. I mean, I think there's a question that you raised as to how the doctrine intersects with Vermont Yankee. And I think Judge Kavanaugh, of course, when he was on
Professor Scalia and Judge Kavanaugh thought it can't be reconciled.
had a problem with that. But
We have to try to reconcile, but that
And
sure
this-
counsels in favor of not being too extravagant in how we apply it.
I think it may counsel in favor of not expanding it, but I don't think we're asking for an expansion here. And I think if you look at, and as you point out, I think there is a fair amount of precedent that really we fall within the heartland of it. Windows covering, American Public Gas, owner operator, Chamber of Commerce. All of these cases we're talking about cost benefit analyses, and there was some notice and comment request. But what was missing was either studies or methodologies. In one case, it says they didn't disclose the way in which they were going to apply this analysis. And here, and I mentioned the federal ones, but there's another one is this concept.
Oh.
Yes, Your Honor.
I'm
sorry.
Stop with, I just have a quick question. So I read those cases, they involved lack of notice on information that ended up changing in part or in whole the outcome of the rule. They were sort of had outcome impacts, the information that was left out. Do you have one where what was not disclosed in the NPRM did not affect the outcome in part or in whole?
Maybe I think my answer to you would be to quarrel with the premise, because I think that these cases, there's a distinction between supplemental information and critical information. But I think a case like owner operator, I don't think it changed what was in the final rule. It did not change the ultimate bottom line that had been proposed.
A significant relevant portion of it. I mean, it had, what was added in had discernible impact. Something shifted from the NPRM to the final rule in something regulatory, shifted in regulatory, something of regulatory consequence.
I guess
You don't.
I don't, that's not how I read those cases. I think, for example, the Chamber of Commerce case, this court had reversed the previous rule for a mistake, what it found to be an error in the cost benefit analysis. And that was
An
correct.
immaterial?
Correct. It was,
error?
well, it was a material error and then it was corrected. So I guess,
What was
Your Honor,
material about it in that?
well, I think it supported the cost benefit analysis, the ultimate conclusion in that case. This court said that there was a mistake there.
But you have here, I guess, maybe I'm not being clear. What you have here is them in the NPRM and their economic assessment, first of all, dealing directly with direct effects. And they did that again in the final rule, and you're not challenging it, the notice requirements, okay? And then all that's going on here is about indirect effects. And in the indirect effects, they did their own sort of qualitative but not quantitative assessment, evaluation, analysis, and the economic assessment, and talked about the uncertainties, acknowledged the uncertainties, grappled with them, and said, here's where it comes out for us. Then you come to the final rule here, they do the same qualitative analysis, and then they get the quantitative one.
I understand.
nothing-
I understand. your
Nothing
question.
of what I see you guys being concerned about, changed anything. These are all indirect effects and didn't change it. And in particular, there's just continued acknowledgement and not dispute by you of the massive amounts of uncertainty that you're even trying to predict here And so I think that's why, those other cases seem.
I think I understand the question. If I could answer it, I think there's three different potential answers to that. The first is, even at a very, very high level, a 30,000 foot level, I think there was a fundamental change to the cost benefit analysis, because in the notice and the economic assessment, there wasn't a conclusion about whether costs outweighed benefits or benefits outweighed costs. They said in the
It was a
note,
qualitative one, but not a quantitative.
not even on the qualitative, I don't think they reached a conclusion as to what one outweighed the other.
He said advantages outweigh disadvantages.
And then the second point is that on the qualitative stuff, Your Honor, there are different qualitative points that were raised here. If you compare, even in the economic assessment, they do talk about a few qualitative things, but they're limited, and actually went through and tried to kind of sort out what they were. And I think you can,
And owner
Right.
operator changed what the number of safe driving hours was.
and I'll get
I don't
into
have that here.
I'll get into the quantitative in a minute. But on the qualitative point, this is at JA 144 to 146. There's 3 pages of the economic assessment, and they mention 4 things: more efficient cleanup, earlier response activity, potentially increased research and development, and health benefits. Those are the 4 qualitative advantages and disadvantages. They say they can't quantify at the economic assessment stage. That's it. They also talk about a 5th thing, which is the transfer of cleanup costs from, quote, public to polluters. Okay, I will give them those 5 things: more efficient cleanup, earlier response activity, increased R&D, health benefits, and the transfer from public to polluters. But there are other qualities. What they introduced within the final rule is other qualitative conclusions. One of them, whether you want to call this qualitative or quantitative, is the exclusion of federal sites. But another qualitative conclusion is that they are going to treat all costs, new costs at non-Superfund sites, as benefits. Another qualitative.
Is that quantitative? I mean, Mr. Lynn, I guess my question is, do your notice and comment violation claims depend on the threshold question of whether costs have to be considered under 102? Because EPA is putting forth both qualitative and quantitative justifications. So if, for instance, their qualitative assessment was sufficient to support the designation, then would there be a notice and comment violation? I mean, your notice and comment violation, critical materials arguments are all based on the fact that they have to consider economic costs, and then they didn't provide the RIA and the relevant information for parties to comment on. So if the qualitative is sufficient, then is there no notice and comment violation? I mean, don't you have to win on the threshold question too, that costs have to be considered?
So I think you're asking 2 different questions, but yes, costs have to be considered. I think it's a separate question what do you do with the qualitative versus quantitative? But yes, costs have to be considered.
Is it separate? Because if costs don't have to be considered, then you have to make an additional argument about why the qualitative considerations that EPA put forth don't meet notice and comment. And I don't hear you making that argument.
I think that is premised on the idea that costs are only quantitative. I mean, when I say cost benefit, I'm happy to adopt their terminology of advantages versus disadvantages. I don't think that cost benefit is necessarily a quantitative analysis. I think I think what Michigan requires is that you look at advantages and disadvantages, and costs are included in that. And that's part of the overall weighing. So that's why I think they're 2 different questions. I think the one question is, does the statute require them to do this sort of advantage versus disadvantage weighing? What goes into that? And then the second question is, did they provide sufficient notice of what they ultimately relied on?
But your notice arguments are largely based on failure to provide economic analysis, like actual costs. not just advantages and disadvantages, right? That they didn't provide the RIA, that they didn't give any of this economic information.
And I think the answer to that, Your Honor, is that, I think what you do with the critical materials doctrine is you have to ask what EPA itself considered to be critical, which I think gets kind of all back to the third answer to Judge Millett's question about qualitative versus quantitative and did it make a difference. The government has argued in their brief that all of this quantitative stuff was just frills on it, right? It was just extra, it was illustrative, they didn't rely on it. But with respect to my friend, I think that's, if you look at the preamble, I think that's a post hoc litigation position of counsel. If you read just starting at JA 26, when EPA talks about the totality of the circumstances test that they have newly created in the final rule, they say EPA weighed the quantitative and qualitative costs and benefits valued in the RIA. EPA considered the estimated direct and indirect monetized costs. EPA also considered qualitative costs. And over and over, it talks about how it took into account the quantitative estimates of costs. And as a point of comparison, so they cite some stuff about, well, they say, well, we specifically said in the rule that we would reach the same conclusion without the quantification. The only place that appears is with respect to the consideration of quantified benefits. And that's at JA 32. EPA believes that the advantages of this action outweigh the disadvantages even without consideration of quantified benefits. It never says that about quantified costs. And I think that comparison is important. You have to take the agency at its own word. It specifically says, and as it is allowed to do, we've done this analysis. We've tried to quantify the benefits and the costs. We think the benefits are sort of really hard to pin down, So even without it, we think the advantages outweigh the disadvantages. They never say that for the quantification of costs. Instead, what they say is that they say things like future response costs are difficult to quantify. Unlike with benefits, though, EPA concluded that it has sufficient information to reasonably estimate anticipated future costs for NPL and non-NPL sites. So I think what this all kind of comes back to is, while the government has suggested that the quantitative costs here are just icing on the cake, what it really is when you read the preamble is it was butter, it was sugar, it was a critical ingredient to the totality of the circumstances.
Can I follow up on Judge Rao's question? So suppose I agree with you that Michigan versus EPA does require consideration of cost, but I don't think either the statute or Michigan versus EPA requires a quantification cost. You with me on that?
I'm with you.
Okay, so as a conceptual matter, we'll get back to how EPA treated the two documents, but they could have done a qualitative assessment in the preamble for purposes of judicial review under the APA. And they could have done hundreds of pages of quantification in the RIA for purposes of an executive order that's not judicially enforceable. And our review would be just on the qualitative in that scenario, right?
With a caveat, but yes, I take it you're going further.
So quantification as a substantive matter is icing on the cake. They don't need to do any of it in order to have a non-arbitrary explanation consistent with Michigan versus EPA.
So I think the issue here, I'm trying to sort this out because I think the way to answer that question is this. Michigan leaves it to the agencies to, I think it says, to how best to account for costs. Mm-hmm. I think we think I would quarrel with the premise of your question, which is I think in order to do a reasonable advantages versus disadvantages assessment here, you have to take into account some of the quantification because these cleanup costs are massive. But accepting your hypothetical, I don't think it matters for purposes of the notice and comment question here, because what the critical materials doctrine or the critical information doctrine is asking is, did EPA give notice of what was critical to its analysis and its conclusion, which is why, with your indulgence, I was reading to you those parts of the preamble. I think what's really important here is when EPA concluded in the totality of the circumstances test in the final rule that the advantages outweigh the disadvantages, what motivated and underlay that ultimate decision? Because if the quantification there was important, and we think it's clear from the final rule that it was.
You do have these cross-references in the preamble to the RIA, which tends to support the argument you're making, which is we have to judge their explanation on its own terms. But boy, if we conclude that the qualitative analysis in the preamble would suffice for APA purposes, and like, it's really not that complicated. This is really dangerous stuff. The statute is focused on, the designation part of the statute is focused on whether the chemical is hazardous to human health. And all of the downstream stuff about who pays what, like CERCLA has guardrails, so we'll worry about that later. Like, that's their basic rationale. And I mean, by APA standards, it hangs together pretty well. So what, we're going to set this thing aside because of some fantastical possibility that buried deep in the RIA are some numbers that might change when they redo the calculations that they never had to do in the first place.
Well, Your Honor, again, I would fundamentally disagree with your reading of the preamble. I think if it were indeed, if all of these these numbers were fantastical icing on the cake, we will be dealing with a very, very different case. But they talk at length in the preamble about the shift in costs, the $50 million per year, the $18 million per year of costs at these sites that are going to be a meaningful advantage and a benefit of the rule. I mean, if I could, at JA 41, this is one that really
preamble now.
This is in the preamble.
Yeah. Okay.
JA 41. This is in the context of discussing enforcement at non-Superfund sites. So this is all cleanup that nobody believes would exist but for designation, because this kind of enforcement against private parties can only happen if you have a designated hazardous substance. Quote, EPA acknowledges that costs parties expend to clean up PFOA and PFOS is a burden on them. But notwithstanding this, EPA views the cleanup monies, I'm sorry, I have a typo that says movies. The EPA views the cleanup monies spent by PRPs as an advantage of the rule. And if you look at that right there, they're talking about $18 million a year of cleanup costs that would not exist. But so there's a bunch of costs that they say would exist even in the non-designation baseline. But these $18 million a year are costs that everybody agrees would not exist without designation. And they are treating these as benefits. And they say that these are an advantage of the rule. And these are the costs that they say they had sufficient information to reasonably estimate that they took into account, as compared to the quantification of benefits, which they specifically say we'd reach the same conclusion even without them, as compared to litigation costs, where they say there's just not enough information for us to quantify that, so we're not going to. Okay, I'll accept that for purposes of this argument, Your Honor. They made a decision that they didn't want to quantify that. But I don't think there is any fair way to read this preamble in the way that the government has attempted to characterize it in their briefs, which is that—
Well, these private enforcements that you're concerned about, they do have to be conducted consistent with the National Contingency Plan. Is that right?
Yes, Your Honor.
And the National Contingency Plan requires, at least when implemented by EPA, specific, site-specific balancing of costs, cost effectiveness, consideration. Then you don't have all of these remote contingencies. Then it's not much more concrete, and you have to do a cost balancing and a cost effectiveness analysis, right?
At that point, yes, Your Honor.
Okay. And so to be consistent with that, do private entities have to undertake that same, again, now it's more focused, costs, effectiveness and costs, pro con, advantages, disadvantages, I forget what we're calling it now, balancing before it can happen.
I do think, yeah, yes. I think
So you can understand how EPA upfront is saying we can't predict with much certainty at all at this point, other than maybe reference historical practice, but which states, which private entities are going to take up these cleanups on their own and then try to obtain compensation where, when, who, how much. And even if they want to do that, they're going to have to show that in undertaking that cleanup and incurring these costs, it was consistent. They did this an appropriate, or at least consistent with, it has to be identical. I'm not sure how consistent it has to be, but I don't know what that word consistent means, but it's going to have to consider costs and cost effectiveness at that point. And so why was it wrong for EPA to say, we think we want numbers, all right, we think based past practice, maybe this is what's going to result. But who and when and where, and whether any of it will actually shake out, because a lot of this stuff is already getting cleaned up anyhow as part of other cleanups. It seems to me you're wanting a lot more, in picking out those numbers, you're not sort of grappling with all the layers of uncertainty and all the layers of protection that actually even still exist for these private and state actions that are going to let you have that very careful analysis that you say you need to have, has to happen. You don't say this can't happen and this can't be listed. You simply say we need to get this beforehand, and you're going to get it beforehand, or you'll have an argument. If someone doesn't give it to you, then you'll have a good way to challenge it.
Your Honor, I think there's a couple different arguments in there. I think we do take issue with the claims of uncertainty and that there are some things that they say can't be quantified and they don't quantify. But I don't think you have to reach that to address the notice and comment issue, which goes to the quantifications in part that they actually did, right? So, Your Honor, some of these questions that you're raising about, they say that they can't calculate.
It's prejudicial if, in fact, they're wrong that the totality of the circumstances analysis, or that their decision that we don't need to do this and or our qualitative analysis was sufficient.
On notice and
prejudice by any of these numbers.
On notice and comment, the question of prejudice, this court has said, is not a high bar. The question is, did we have anything useful to say?
You have to win on the argument that they had to do a quantified, a dollars cost benefit analysis. Because if the statutory answer is they give us sort of three options on the table, we don't have to do it at all at this hazard designation stage. The cost benefit analysis is going to come later, much more site specific and focused. That's one. Two, to the extent we have to do a qualitative beyond the direct effects. So for the indirect effects, qualitative is permitted and we've done that. Or three, it has to be number crunching. And you have to prevail on it has to be three. It has to be number crunching for us to say, well, when they predicted a range of expenses for private and state actions, they had to get that better?
I don't think so. I think the way I would suggest you think about the analysis is this. One, do they have to do an advantages and disadvantages weighing at all? I think the next question is, what did they do? But the first question is, did they have to do an advantages and disadvantages weighing at all? And I think the answer to
That's my
that is
number one, so you have to win on that.
yes. And I think the answer to that is yes for a number of different reasons.
No, I understand your argument. I'm just saying you have to win on that before you even prejudiced by any of this.
Yeah, and so right, so then we'll move on to that because
And your arguments on
but so the first is that, and I think the answer to that is yes for a number of reasons. One of which is the government has conceded for purposes of this case that they had to consider costs. In the preamble, they said kind of both things, but they've come into court, page 39 of their brief, and said
Qualitative or quantitative.
they have to do some sort of weighing. Appropriate means you've got to look at the relevant factors and weigh advantages versus disadvantages. I think the answer to that is yes, whether it's on a party presentation ground or if you look at Michigan directly. I think Michigan, the way the statute's set up applies to that. We can talk about that, but that's question one. I think as to 2 and 3, Judge Millett, and this gets back to my dialogue with Judge Katsas, I think they sort of collapse into, and what did EPA think was critical to its analysis, right? Because if EPA says we had to do an advantages and disadvantages, the next question for purposes of notice and comment is, what did they do and what was critical to their conclusion? And that is the sort of colloquy that we had, which is, I think the preamble makes very clear that the numbers that they did crunch, at least with respect to costs, they absolutely relied on them because some of those costs, 18 million and 51 million, they considered benefits. And I think that is the question. I don't think we have to win on, do they have to consider quantitative, because they did.
I don't think they said we considered this particular dollar amount the benefit. I think they said we, as a statute, as a design, consider the transfer of these costs, which is going to happen at some point. It's to some degree to be a benefit because the statute considers that a benefit.
Well, right. And that gets.
I don't read their decision that if it's not 18 million, then we would decide this. Then we're going home. We're not regulating this.
So one, I think they do, but two.
You think they say that if the benefits are not this dollar amount, the dollar amounts we've identified or that range, then we would not regulate this as
I spoke too quickly. I'm sorry. There is no sentence that says that specific
Do you
thing.
even think that's
I think
the
it's.
decision they made?
I think it's part of it because they call it a totality of the circumstances test. They don't identify which 10 things are on this side of the ledger and how you weigh them against the other 10 things. What they do have at, and again, I'm sorry, I've lost it now, JA, I think it was 387, they have a table in the RIA that they refer to, the cross-reference from the final rule, that has the 29 different impact categories that are the costs and benefits that were taken into account in the totality of the circumstances. And they don't tell us exactly how you weigh one thing or the other. They do at one point say the quantification of the benefits, we can sort of take or leave.
So Mr. Let me ask another question. Is your notice and comment argument contingent on the fact that the reasoning is arbitrary and capricious?
I think it's contingent.
Because many of these arguments that you're making now are not about, critical materials and notice per se, but just that internally the rule is unreasonable or poorly reasoned, or
Well, I think
you
it,
can't sort of trace the reasoning.
I think it's both, because I think
And are they separate or are they connected?
they are connected in part. So the notice and comment analysis, I think we have to identify some things of which we were not given notice that were critical. And then we have to establish prejudice. I think the arbitrary and the prejudice argument knocks up against the argument that the reasoning is arbitrary and capricious. But under this court's cases, we don't have to actually win the arbitrary and capricious argument on those things of which we weren't given notice, right? We just have to show that we had something useful to say that would create some uncertainty as to the outcome. But the court has said, we don't have to show that it would have convinced the agency to go the other way on those pieces of it. But one other thing I did want to stress is,
Sorry, it's at some level, it cannot be that when you have, you pointed out how long and comprehensive and multi-factored this weighing of advantages and disadvantages was, both qualitative and quantitative. And all you got to do is find one number and say, Oh, we would have told you a different number. And then we always send it back. It's
No,
a
not-
never-ending cycle.
Not always, but the problem here is with the way EPA did its analysis. You can, just as a hypothetical, if they had actually done, and it is not, I'm saying that they had to do this, right? But if we had a different case where they said there are $100,000 worth of benefits over here, and there are, $50,000 worth of costs over here, and then there's some other qualitative benefits that go above and beyond that. And if we found a problem with you would know better which pieces of those, how they fit together in the analysis. But EPA here has chosen to do what they call a totality of the circumstances test. So they haven't built the Jenga tower for us to understand what each individual piece does. And I think what we've identified
Your
are,
burden to show prejudice.
yes,
And agencies do totality of circumstances analyses, not uncommonly, and they're allowed to do that. Michigan versus EPA calls for that. And so I don't understand what that means. If you say they have to give you some sort of analytical framework, sort of a whole program here that says, and by the way, if this one changes, oh, that's bad. If this one changes, it doesn't matter so much. I mean, I think the burden's on you, and I'm having trouble understanding, especially when you're mixing qualitative and quantitative in the balancing, how simply your objections, which seem to be really very data specific, this number versus that number. Well, we would have told you this number versus that number, not motive analysis, not what they've done. You didn't consider this, or you failed to add that one in. You have to show that it was going to make a difference, don't you? You're big enough to make a difference.
no, I don't. Not in this, as a general matter, the prejudice standard does not require us to show that we would have convinced the agency to come out in a different way. All it requires is for us to show that we had something useful to say.
We're going in circles here. It has to be, it can't, because I thought you agreed, it cannot be, wait, we had 50 cents more to add, right? You could have added that. I think we would say that's not useful and that it's not going to be material to an analysis. And so don't you have to show, it's not just that we have a different number. Courts are rarely ever going to say which of the two numbers for an agency in a technical area like this is right. So it has to be more than just we had a number. We had a number that could, you don't have to show would for a notice, but that could have changed this.
And I think we have done that for two reasons. One is that these aren't just numeric complaints. And Your Honor, I think I sort of was unable to circle back around to your question before about the 18 million. If the 18 million were different, would they have sort of taken the ball and gone home, right? The complaint about the 18 million, and this gets to Judge Rao's question before about is it quantitative or qualitative? I think there is a qualitative element to our complaint about that. And then there's another thing, which I haven't mentioned yet. But on the 18 million, it's how they're treating that 18 million. Whatever magnitude that number ends up being, the point is that they have decided, the EPA has decided that 18 million of new costs will be treated solely as benefits. That is a big conceptual swing, no matter what that number is. Things that should be in the cost column.
Why can't they just make a first cut global assessment that these chemicals are dangerous enough that they should be cleaned up? And then all of the particulars about, what if it's just 1 part per trillion and it's not worth doing, it just gets handled post designation.
So, Your Honor, I think just to make sure I understand, you're asking a sort of the threshold question about.
They can just make a general assessment. The only question before us is, could they permissibly designate these chemicals as hazardous? And they look at the science, and you haven't contested any of this. They conclude these chemicals are really dangerous and cause birth defects and cancer and everything else. And the conclusion is, as a general matter, right, arbitrary and capricious, we're not fly specking too much. They say there should be cleanup. And that's true regardless of whether it's whether the site is on the national priorities list or who's going to do the initial cleanup, who's going to get hit as a potentially responsible party. Just seems like that's a categorically rational decision on the threshold question, whether to designate or not. And then you have all these details on the back end about, you know, which sites do you do first and how much do you have to clean up, and do you not bother if the concentration is really, really small?
A couple answers to that. I mean, again, I think the first answer to that, Your Honor, is that's not what they did. They have said they did.
But that's, I'm suggesting that might be what they're doing when they say this is really a benefit. This is a net benefit. Cleaning the stuff up in non-NPL sites is a benefit, you know?
And but it's part of the way that they weighed advantages and disadvantages. And it's a totally new method or assumption about how you think about whether those costs are advantages or disadvantages that they didn't give us notice of. And we could have had this very debate with the agency if they had actually provided notice and comment. I think that's really, I mean, that's ultimately the notice and comment complaint, is that there are whole pieces of how they thought about the advantages and disadvantages. Some of them are numbers, others of them are not. Another example.
So, Mr. Lynn, would you have the same argument if the preamble said perhaps more clearly something like what Judge Katsas said, that we are making a qualitative judgment that these are hazardous substances that need to be regulated, and we have an economic justification separately? Would you have the same argument about?
I think it would be a different case.
It would be a different case.
It would be a different case on the notice and comment, although we would, I think on the qualitative judgment, we'd have to see what went into their qualitative judgment. If it was Judge Katsas's like kind of a one-liner about, well, we've sort of generally weighed the qualitative.
Well, that was partly why I asked the question towards the beginning of this argument, which is, do you have to prevail on the threshold question about whether costs are part of 102? Is it, because if it's sufficient to simply do a kind of, you know, qualitative assessment about what's a hazardous substance, then can you still prevail on your arguments?
I think we can, because on the notice and comment.
Because of what they did, but not necessarily because of the law.
Well, but those two things go together, right? Because
Sorry, finish.
I'm sorry.
No, go ahead.
No, go ahead.
Because if the law requires that they do an advantages and a disadvantages assessment, which again was sort of step one to the analysis, and they do it and they reach that conclusion based on a number of, whether it's data or methodologies or assessments that they don't give us any notice of and any opportunity to comment on, and that is the basis for their advantage and disadvantage assessment, then there is a notice and comment violation. And the question is whether that was prejudicial, right? That's the next question.
102 is just a purely precautionary provision. And EPA can decide that something is a hazardous substance because it affects the environment or human health. Then do you have a winning argument?
If they don't have to do the advantages and disadvantages.
Well, advantages and disadvantages is so broad, but.
If they don't have to do anything other than consider whether the substance is hazardous.
Yes.
Then the notice and comment argument does fall away, because that is premised on the idea that the word appropriate in the statute requires them to do an assessment of these.
Some kind of assessment.
Some kind of assessment. Again, as we've talked about, I think the government has conceded for purposes of this case that that is what that Michigan does require them to do
You
that.
can see that they
weighing.
just assumed without deciding that they win anyhow. That's different than a concession.
I think what they have, maybe the way that I would put the concession is they have said to this court that it should be assumed in this case.
Yes, EPA assumed without conceding at the final rule stage of the section 9602 was not.
And therefore, the only live issue in this case is whether the costs.
I'm just clarifying. your
Yes.
concessions. That's important.
I think if you read on in that paragraph, it says that, and therefore the only live issue here is whether the cost benefit analysis or the advantages and disadvantages weighing was done correctly. And so I think they're asking this court to assume that they were required to do that. And the question is whether they did it correctly. And whether they did it correctly, one question is whether it's arbitrary and capricious, but a threshold question is whether they provided sufficient notice and comment. Some of them are numbers and some of them
They
are.
provided this $18 million number in the NPRM. They give you, said, this is what we think this advantage is. Where have you shown what you would have done differently other than substantively debate whether it's the statute allows them to consider that an advantage?
What we've said about, oh, I'm sorry, I missed the last part of your
If they
question.
give you the note, so we didn't have the notice. I mean, one of the ways we think about prejudice is, well, if you usually people say, well, had they
Yes.
told me
Yes.
this, then we would have done. Had they told me X, we would have done Y.
There are two objections that we have
Mhm.
to the $18 million number.
Omission from the NPRM.
One of them is that they considered that 18 million, again, could have been bigger, could have been smaller, that they considered it as a benefit and not as a cost.
That's more a legal argument than a notice argument, isn't it?
I think it is still a notice argument because it deals with how they ended up. And this gets to the quantitative versus qualitative. I think it's qualitative in the sense that they decided they're going to consider that whole category of
You've made all
stuff.
these arguments, right?
We did not make that argument in the comments because they didn't preview that they were going to take these new costs and treat them conceptually as benefits. And the other thing, so that's one objection, and that's a qualitative objection. As to the actual $18 million number, that only counts federal enforcement. And they say that they're not going to calculate in that 18 million what happens with private and state enforcement at those non-Superfund sites. And one of the things we point out in our brief is that historical data shows that only a third of enforcement at those sites is by the federal government. And so, again, if we had had an opportunity to comment on it, we would have explained that that is a woeful undercounting of the costs that will occur at these new sites because 2/3 of enforcement occur by somebody other than the federal government. So I think we did have, not to overuse the phrase, but useful comments about.
They would have just upped the benefit value.
Maybe, who knows? And who knows how they would have done it? But that's the whole point of the notice and comment process. And the other qualitative problem that we have, which I haven't gotten to, is they count these operational changes to sort of cut down on the potential releases of this chemical as a benefit. It's included in the chart at 387 to 389 as a benefit. But then in the totality of the circumstances analysis, they tell us that they're not going to consider the costs of those actual changes. Again, I don't know if you want to call that quantitative or qualitative. There are no numbers attached to that, so let's call it qualitative. It's a qualitative conclusion to count only the benefit of operational changes to cut down on releases of PFOA and PFOS, but then they refuse to count what the changes would actually cost.
I thought what they said is it's complicated because it's no longer being manufactured in this country, correct? These two
That is correct.
substances are no longer being manufactured. So you don't have those types of costs. And so then you simply have questions of, it coming in, I guess, through imported products. So you have that complexity of them trying to predict. So it's not going to be the sort of linear analysis of you counted it here, you didn't count it there at all. I think they explained why they were doing what they were doing. And it also gets more complicated in this case because there are other statutes that keep kicking in covering a lot of this stuff, whether it's hazardous waste or other, there's a whole network of statutes that are covering, and these are already, some of these costs are already getting covered under these other programs anyhow. And then the PFOA and PFOS are often only getting cleaned up when, and this could be, I don't know why this would be any different for private and state enforcement rather than federal. It's at sites, if they're already cleaning up the sites, this is getting cleaned up as a part of that. There's not, so far as they said, they don't think that there's huge amounts, or they're unclear how much of it's going to be a pure PFOA or PFOS cleanup. So it's on top of things that are already getting cleaned up. So you have to be able to figure out how to back all of that out. And so I think they've dealt with the uncertainties and the complexities and the, not only is it not linear, I mean, this thing is, an absolute jigsaw puzzle in trying to sort of even trace things. They weren't playing the game that I think your analysis was suggesting. We're going to only count the good and not the bad. But they explained it. And I don't know what more we asked of them in this context.
Your Honor, what they say is that, here it is, J387, said they count under deferred benefits the requirement to report releases may lead to improved handling, storage, transportation, and waste management and treatment practices. And then they say in their brief that the costs of those practices are not fairly attributable to the rule.
Because waste management's already regulated.
But why would you count those changes as a benefit when you don't count the costs of making those changes? That is what Business Roundtable.
Except there's any costs, it's a benefit, but a lot of it's already getting captured. I mean, you're the ones who have to show there's something material.
Your Honor, with respect, I don't think that's what the agency said. I don't think
that could have, if not would have.
I think
cause a different outcome.
I think that they say that they count these as deferred benefits, which is why this table is so helpful. And then they say that the cost side of that in their brief at 62 to 64 is not fairly attributable to the rule. That is an internal inconsistency in how you treat costs and benefits under Business Roundtable. I did have the statutory argument if this court is interested in discussing
I
it.
just have a quick question about your non-delegation argument. So my reading of your brief is that you were not challenging Section 102 as being an unconstitutional delegation.
Correct, Your Honor.
Okay, but then I'm not sure what your argument is. I'm not sure exactly what you're asking this court to do then, because I mean, Justice Scalia is very clear in Whitman that agencies can't cure an unconstitutional delegation with a different interpretation. And you seem to be suggesting that the interpretation EPA has adopted raises constitutional concerns, which suggests that they could adopt, a different interpretation that would address those concerns. I'm not exactly sure what what even ideally you would like from this court with your non-delegation argument.
Your Honor, I think you're pretty close to it. So I think our argument is the statute is being read in a way that is allows them standardless and limitless discretion to designate substances, and that runs up against the non-delegation
But the
doctrine.
question is does the statute lead to standardless, no intelligible principle decision-making? And you're not arguing that the statute lacks an intelligible principle or violates the non-delegation principle.
So the next step to the answer is, so our argument is that their interpretation of the statute is incorrect. And what we are asking this court to say is that their interpretation of the statute as allowing for a possibility, but not a certainty of substantial danger is so broad that it runs afoul of the non-delegation doctrine, that it's inconsistent with the statutory hierarchy, and that you should vacate the rule and send it, and give them another chance if they would like, as they have indicated that they would in this press release that is cited in the briefs, to interpret the statute correctly and in a way.
We would just say this interpretation is
incorrect.
Is incorrect, but what would we say the correct interpretation is? I don't see that in your brief.
I don't think this court has to interpret.
It was a little, if we under Loper Bright have to say what the law is, we just say, well, it's not what the EPA says. but that's it.
I think that that's right, Your Honor. With respect, I don't think Loper-Bright tells you that you have to, in every case that raises a statutory question, and interpret the statute. I think what it says is the court exercises independent judgment, and it doesn't defer to the parties or the agency. And so the question is, did they get it right?
But usually when you say that the agency has gotten it wrong, courts have some account of what the right interpretation is.
We have
Which
suggested.
I don't see what that would be from the petitioners.
We have suggested in our reply brief that may should not be read as possible, but something more like able to. We have, when we talk about when you have may in the contingent clause with when released into the environment, blah, blah, blah. So there are other interpretations of the statute. We haven't asked this court to adopt that
Do you have an
interpretation.
interpretation that wouldn't cover these chemical substances?
It's hard to say whether the science would actually satisfy the interpretation that we've set forth.
Do you
in the
have an
reply.
interpretation that you believe it would be unlawful for them to say this meets? Do you think you're able to wouldn't be met, isn't met even on this record?
I think a few answers. One, I think this court can't actually uphold the rule on that ground because it would be a different statutory interpretation. But to answer your question directly, I can't say, based on the science, whether EPA would ultimately be able to reach that
Their
conclusion.
findings don't show that this is able to cause these things.
What the findings show, and Judge, Katsas, I was going to point this out earlier. You had suggested that they said that it causes all of these things. I think if you look at what the findings say, it says that they're associated with certain health effects, right? And look, we acknowledge that under a correct reading of the statute, which I think would be more restrained than possible, there is still some discretion for the agency in figuring out whether the science meets that standard. And we just can't know how that's going to play out in practice until the agency operationalizes a correct and new reading of the statute.
Thank you very much, counsel. We'll give you some time for rebuttal.
Thank you.
If you want to write.
Good morning, Your Honors. Riley Walters for EPA and Administrator Zeldin. I'll start here on the top with the notice and comment argument. Interested parties were on notice that EPA may consider costs in the final rule. EPA solicited a comment on the cost question, and this was not just a bare request for comment, as my friend suggested. EPA solicited a comment on every aspect of the question. This is at JA 78.
Well, what does it mean to solicit comments on costs where the agency has top line position is costs don't matter?
Well, Your
And
Honor,
then, but yeah, please go ahead and give us some comments on costs. Like how can those comments possibly address what the agency is considering when they've said that costs don't matter?
so, Your Honor,
Because that's what it said in the proposed rule.
two responses, Your Honor. So EPA did provide an economic assessment that provided the basic framework for how it was thinking about the cost issue. And in the actual solicitation for comment itself, EPA said, do we have the statutory authority to consider costs, or are we required to consider costs under the statute? If so, what costs and what benefits should we consider? How should we weigh those costs and benefits? And how do those costs and benefits factor into the ultimate designation decision? And then EPA provides the economic assessment that lays out the general framework.
Well, that's more like a request for information than comments on what the agency is in fact doing or the justifications that they have for their proposed rule. The justification is we don't really need to think about costs. Here are some top line considerations of advantages and disadvantages. Please give us information about costs and benefits.
Your Honor, I think,
I know those things just don't match up.
Your Honor, I think the agency did a little bit more than that in the economic assessment. So for example, in the economic assessment, EPA, went through the general categories, direct costs, those were the reporting costs. EPA provided a quantified figure there. EPA looked at direct benefits such as better information on the scope of contamination and faster cleanups. That was noted as a benefit. It also looked at costs.
How does all that match up with the 300-page RIA?
Your Honor, I think the 300-page RIA is the logical outgrowth of that because, again, EPA was relying on the same general categories and simply expanded on that framework. And I think the best evidence that petitioners had a meaningful opportunity to comment on the cost question is the fact that they did comment on it. The chamber submitted a 20-page cost report with quantified numbers, and EPA considered that information along with information supplied by other interested parties, and it explained why it disagreed. And so the notion that petitioners were surprised by the cost analysis in the RIA, I think is hard to square with the record and given their own comments.
Well, so they commented, but they didn't have notice really of what EPA was going to, of at least any kind of detailed information. I mean, the fact that the chamber could pull together comments about costs that they thought the agency might consider to be relevant. It's not, it shouldn't be on regulated entities to guess what kinds of costs and benefits an agency is going to take into account.
Your Honor, I don't think, and this record supports that they were guessing. Again, in the economic assessment, EPA provided extensive information of the types of costs and benefits it was considering, and most of these were qualitative. Almost all of them were qualitative, and these are the same qualitative costs and benefits that were considered in the RIA. And this went out for comment. Petitioners had an opportunity to address, for example, if EPA was thinking about this wrong, if EPA needed to provide a more robust quantitative analysis, if a qualitative analysis would have been insufficient, they had the opportunity to do that. And I think under this court's logical outgrowth cases, that's more than sufficient.
How do you reconcile your position with cases we have like owner operator, which seems to treat methodology as its own category and something that must be disclosed to some degree, must be disclosed at the outset?
So you're right.
And does it on an incredibly hard look basis, like one aspect of the cost benefit calculation, one aspect of that methodology didn't get disclosed, and we reversed on that basis.
Yes, Your Honor. I think owner operator is a critical materials doctrine case. What the court said there was that the particular methodology that did not go out for comment was
critical materials, which sort of suggests like the, hiding a secret study point, but in fact was about an undisclosed methodology.
Right. It was about a methodology. Totally, we agree, Your Honor. And what the court said in owner operator was that methodology was an integral part of the model that itself was the central justification for the rule. And so the court said that the public lacked the opportunity to comment on the most critical factual material in the case. We don't have anything like that here. Here, the general framework for how EPA was thinking about the costs did go out in the economic assessment. What my friend on the other side seems to focus most on here are the quantified illustrative estimates. And those were not a critical part of the cost analysis, and the cost analysis was not the central justification for the rule. So I don't think owner operator is anywhere close in this case.
I would agree with you if you had written the preamble a little bit differently and said, this is the qualitative analysis that we want to stand on for APA purposes. And we've done this whole other number crunching thing for the EO. But there are these seeming cross references in the preamble where you did seem to take on the whole burden of that multiple 100-page thing. I don't know why you would do it, but you seem to do it.
So, Your Honor, I think the question of whether EPA considered those numbers is different from whether they were critical material in the case. So it's true, Your Honor, in the preamble, EPA did note that it considered the quantified figures, but it noted throughout the preamble and in the RIA itself that these were merely illustrative. It notes time and again, for example, at JA 26, that the RIA doesn't fully capture the costs and benefits because there's just too much uncertainty. JA 36 and 37.
Give me your best shot, best one or two sites in the preamble for the proposition that the agency would have done the same thing without the RIA.
So I direct you to JA 26, Your Honor. And again, EPA did not use that exact language, but it goes to EPA was expressing the fact that there is so much uncertainty associated with these quantified costs and benefits. And
where on 26? I have kind of the money quote is maybe a third of the way down on the left-hand column, which says the analysis included consideration of the RIA.
So the far right column, Your Honor, on JA-26, last paragraph where it says, first sentence, the RIA does not fully capture the quantitative cost or benefits of the rule due to data limitations. And
But Mr. Walters, I mean, EPA also says that it is assuming that costs and benefits have to be considered.
right.
But then it says it's only using the costs and benefits as illustrative. So how do you have it? Either it seems that EPA should rest on the fact that Section 102 allows it to make a purely qualitative or hazard-based determination. That's one justification. But on EPA's own reasoning, it says it's assuming that it needs to do this type of balancing, and then it points to the RIA and other economic justifications. So then doesn't that have to be reasonable on EPA's own terms?
Yes, Your Honor, it does need to be reasonable, but EPA, again, assumed that it had to consider costs and benefits. It did not assume that it needed to perform a quantitative analysis of costs and benefits. And the only figures that are described as illustrative are those quantified figures. We agree for purposes of this analysis, EPA did need to consider qualitative costs and benefits. But under Michigan, the court went out of its way to say it was not requiring agencies to assign a monetary value to each cost and benefit. It recognized that a qualitative analysis may be appropriate in certain contexts. And we think this is a context where a qualitative analysis provides more information.
So then does EPA have to prevail on the threshold statutory question that Section 102 does not require consideration of costs?
So no, Your Honor, we assume for purposes of this analysis that we did have to consider costs, not quantitative costs. Again, because we're at the designation stage. This is a preliminary stage in the circular cleanup process where there's just not enough information to provide robust quantitative analysis. And so we don't think the court needs to decide whether EPA is required to consider cost. However, if the court thought that EPA erred in its cost analysis, and that was, the issue in the case, then I think the court would have to decide the question of what the statute requires. But we don't think the court has to reach that in this case.
Because the qualitative assessment is sufficient.
Yes, Your Honor.
And the 300-page RIA is just illustrative, so it's not critical material.
No, we're not, make it very clear. We are not arguing that the 300-page RIA is just illustrative. We're talking about the quantified figures, the four quantified estimates that EPA acknowledged were being made based on imperfect assumptions and a lot of uncertainty. EPA labeled those estimates as illustrative. The qualitative analysis was not illustrative. That was part of EPA's weighing of the advantages and disadvantages in the case. And Your Honor, Judge Katsas, going back to your question, for one more site I think that may be helpful here is in the RIA itself. It's JA 592. In here,
in the RIA.
It's in the RIA, yes, Your Honor. There, EPA said that significant uncertainties prevent a robust quantitative analysis here. And so if the agency was treating these quantified figures as critical to the rule, I don't think the agency would admit that these are not robust figures. That would be an admission to arbitrary and capricious decision-making. One more point on whether these illustrative figures were critical to the rule. Michigan v. EPA said the word appropriate requires consideration of all relevant factors, and cost is one of those factors. So, agencies can't ignore costs when Michigan applies. But again, they're just one factor. They're one quiver in the appropriate, or they're one arrow in the appropriate quiver. And EPA considered them as such. EPA also considered surplus purpose and whether designation would further surplus purpose. Also considered whether there were other authorities that the agency could use to address PFOA and PFAS, and it concluded that CERCLA was the best authority that was available. And so these illustrative estimates were just one minor aspect of the cost analysis, which itself was just one minor aspect of the totality of the circumstances analysis under Michigan. And then all of that was just one aspect of the designation decision, which turned primarily on the scientific finding of substantial danger. And so I just don't think the record supports the claim that these illustrative figures were critical to the rule. It would have been better if we had said that more explicitly, Your Honor. I'll concede that, but I think there's enough in the record to agree with our position on that question. And so I think that.
I'm inclined to agree with you to the extent we think of this. The first two of their 4 or 5 arbitrary and capricious challenges, which seem to me the strongest, are one is a quantification of a range of 10.3 million to 57.1, and the second is the range of 327,000 to 18.1 million. And if we just put blinders on, look at that chart and say, is there a significant enough likelihood that the bottom line would change if those numbers were adjusted? That seems unlikely to me. But what if we take a step back on the notice and comment and just look at the whole scheme? And nothing was disclosed about the methodology for calculating any of these costs and benefits. I mean, to borrow a phrase, these two problems from their perspective are just illustrative of this global problem that they had no idea how you're going to go about thinking about this problem and or making these calculations.
Sure. I'm sorry, just so I understand the question. Is the question, would there be a notice and comment?
Yeah, the notice and comment problem is broader than just the specific arbitrary and capricious objections.
Understood, Your Honor. So I think to the extent petitioners are arguing they didn't have a chance to comment on the quantified figures, which I know you were addressing here, or the assumptions behind those figures, for example, the assumption that EPA would bring enforcement actions at 67 non-MPL sites. We think those assumptions are part of the quantified estimates, and so that's all the same bucket. And my understanding from petitioners' arguments, there really is only 2 other buckets of issues they say did not have a chance to comment on. One was this allegation that EPA characterized certain costs as benefits, Your Honor, and I just don't think the record supports that. In fact, the page that my friend cited, JA 41, he even quoted language where EPA recognized that these new cleanups that are taking place because of enforcement actions are costs for PRPs. And EPA even said that these cleanup costs were a quote burden for PRPs, but EPA reached the conclusion that the benefits justify those burdens. And EPA did say that it considers this an advantage of designation. That's because it furthers the purpose of CERCLA for polluters to pay for the contamination they cause. I mean, criminal statutes, for example, when they're enforced, they impose costs on criminals. When someone is put behind bars, that's a real cost. But we wouldn't say that there's no advantage to enforcing the criminal law. It also serves other purposes. And I think that's
there's sort of Orwellian quality about the way that you talk about costs and benefits. So what you're at some point talking about real costs and burdens, but then when you want to flip the switch, you start talking about advantages and disadvantages. I mean,
well, Your Honor, I think
there's sort of through the looking glass quality about the way these costs and benefits are being talked about. Yes, it's a burden on private parties to do cleanup, but we're going to take that as a benefit of the rule. I mean, I don't know how that's being mischaracterized by the petitioners here.
Your Honor, we didn't say that cost was a benefit of the rule. Again, EPA
we said it's an advantage of the rule.
The advantage
or
is
something like that. Well, is that different from being a benefit?
So, Your Honor, I think EPA's use of the words advantage, disadvantage, in many places are just interchangeable with costs and benefits, but it also is broader because, again, under Michigan, the appropriate language requires us to consider all relevant factors. One of those things EPA considered here was CERCLA's purpose, making polluters pay. And so when it's using advantage there, it's talking about there is an advantage here in furthering the purpose of.
On that reasoning, anytime a regulation furthers the purpose of a statute, and let's hope that the government is only regulating when the regulation would further the purpose of a statute, that regulation will always be advantageous. I mean, that's the reasoning of the EPA. So anytime a regulation is doing something that's within the statute and within the purpose of the statute, it's all beneficial. It's all good for society because it's furthering the purposes of the statute. I mean, that has no connection to how we have thought about costs and benefits or advantages and disadvantages. If every regulation that furthers a statutory purpose is advantageous, then there are no limits whatsoever on the EPA's regulatory power.
Your Honor, I agree with you. If we had ignored the costs that these enforcement actions impose on PRPs and just said it's a benefit because it furthers surplus purpose, that would have been error. But we did not do that here. In fact, the chart, the helpful chart in the RIA, JA 387, this is page 7 of the RIA. It lists all the costs and benefits. Labeled under indirect costs are costs related to enforcement actions, the 327,000 to 18.1 million. So EPA treated these as a cost in its cost analysis. So again, Your Honor,
You treat it as a cost, but then you wave away the cost by saying it's an advantage.
Yeah.
So, I mean, isn't that the same thing as just treating it as a benefit?
No, Your Honor, because I respectfully, I disagree that EPA just waved away the cost. In the language that my friend cited, EPA acknowledged that it was a cost and acknowledged that it was a burden. And then it said the benefits justify that burden. And then it also said it was an advantage to further surplus purpose. So I don't think the advantage language was canceling out or erasing the prior language where EPA is acknowledging that it's a cost. It's a complex analysis for sure. But again, I would go back to the criminal statute. You can both acknowledge that enforcing criminal law imposes costs on certain people, and then also acknowledge that there are advantages to enforcing criminal law. They serve the purposes of deterrence. They serve the purposes of incapacitation. And I think EPA was doing something similar here.
So is there any situation, though, where the advantages of furthering a statutory purpose would not be greater than the costs of something? It's the sort of generalized reasoning that CERCLA has these purposes, which of course it does. And, these substances, no one is questioning that they are harmful. Mm-hmm. Okay. But there's still a question of how we weigh the harms of that against the costs that it imposes on private parties.
Right. Your Honor, totally agree. And the question in these cases is whether the agency engaged in reasoned decision-making. And I think there's a lot of deference that's owed to the agency in weighing costs and benefits in a complex scenario like this. And so I think the question here is, did EPA acknowledge costs? Did it acknowledge benefits? And how did it weigh them? And I think EPA did that reasonably here, especially given the stage of the process we're at. And again, just to make it abundantly clear here, so there's no doubt, we agree that EPA could not just relabel costs as benefits and ignore important costs that are imposed on society.
Can they rename costs as advantages, statutory advantages to the public?
It cannot ignore the cost. If EPA was ignoring costs and just saying, oh, well, it's a good thing, and so we're just going to label it an advantage and not even recognize that it's a cost, I think that would be a problem.
So it's sufficient to recognize there are costs, but then whatever the costs are, a statutory advantage can overcome that.
Your Honor, EPA reached the bottom line conclusion that the advantages of designation outweigh the cost.
Well, that decision has to be reasonable.
It has to be reasonable. So did the agency...
Justified and explain.
Exactly, Your Honor.
So if you decided it would promote CERCLA to have every single microscopic piece of these substances removed from the United States, and it's going to cost billions of dollars to do that, but that would be consistent with CERCLA's purpose. But then
that would be a situation where designation very well may not be appropriate. And I can think of other examples for if the only available cleanup technology for removing this substance would cause even more danger to public health or the environment, that may also be a reason not to move forward. Or if the only available cleanup technology imposed extraordinary costs on society, if it cost $1 trillion to clean up this substance, that might be a reason not to move forward. So there are plenty of examples where I think cost could make a difference here. Here, EPA acknowledged costs, it acknowledged benefits, it engaged in reasoned decision-making, and I think that supports the decision.
Right. Thank you very much, Council. We'll give you some more time. We won't give you more time, but never mind. Thank you very much, Council. We'll hear from the intervener.
May it please the court, I'm John Kelmus-Katz for the Environmental and Community Interveners. No party disputes the most critical fact in this case. PFOA and PFOS may present substantial danger when they are released to the environment. That is the standard for designating hazardous substances under CERCLA, and petitioners have not provided any basis for overturning the designation of these highly toxic, persistent, and pervasive carcinogens. Today, I'd like to begin with the notice arguments the court has been discussing, and then I'd like to briefly address petitioners' claim that EPA's interpretation of substantial danger lacks limits. So, Judge Katsas, you had asked for record support for EPA's position that the cost estimates were not critical to its ultimate decision. In addition to JA 26, which we agree supports that, the first page of the rule, this is JA 002, refers to the RIA as an additional discretionary analysis. And I think that is how it was treated here. All parties agree that notice is only required for materials or pure assumptions that are critical to the agency's ultimate determination. The RIA and its quantitative cost calculations were not critical for three reasons. First, and I would actually like to put a pin in this one because I don't think the court needs to reach it, there is a justification provided in this rule that does not consider costs at all. And CERCLA does not require EPA to consider costs here. So that is a basis for rejecting the notice argument. However, even if the court were to find that Michigan applied and that some consideration of costs was warranted, the RIA and its quantitative calculations would still not be critical. Michigan is very clear that agencies have broad discretion in how they assess for costs. And here EPA did provide the economic assessment with its proposed rule, which quantified direct costs and qualitatively addressed indirect costs. That satisfied any requirements that may have been imposed by Michigan or by CERCLA. And I think it is particularly important here, given the preliminary stage that this case is reaching this court. This is a decision about whether to add 2 substances to a list of some 800 hazardous substances. Any decisions about how to remediate the substances, where to remediate the substances, the decisions that really drive the analysis of costs are going to occur much later on a site-specific basis. And that is where Congress required EPA to consider costs. So to the extent that any cost consideration was required, it was satisfied by the economic assessment that was provided. Moreover, if you look at the agency's totality of the circumstances analysis, and this is at pages JA 26 to 41 of the joint appendix, I think it becomes readily apparent that the specific cost estimates that petitioners are discussing, and even these conceptual kind of approaches that they claim were first announced in the RIA, and we would take issue with some of that, but they were not critical for the agency's decision. That is a 16-page analysis, which on its whole is overwhelmingly qualitative. In fact, I think the only page that references the specific cost estimates that kind of petitioners are talking about is the one that they mentioned at argument. There is one reference to qualitative cost estimates. If you look at that in the context of the totality of the circumstances analysis that the agency conducted, which looks at the harms associated with these chemicals, which looks at the statutory purpose, there's really no reasonable reading of that analysis where the court would conclude that these specific figures were the fulcrum, that these were the critical aspect of the agency's decision. I would...
Can I just take you back to JA2 for a second?
Certainly.
The agency says we made the statutory assessment of substantial danger.
Yes.
And then it said we did other things that were discretionary.
Correct.
But it folds into those other things, not just the RIA, but more broadly the assessment of advantages and disadvantages.
Well, Your Honor,
that seems to tee up the Michigan versus EPA question.
So it...
I'll put my cards on the table. I don't think they're required to quantify, but I do think they're required under Michigan, at least qualitatively, to consider costs and benefits. And this passage that you pointed me towards seems to treat all of that as discretionary.
To the extent that is Your Honor's position, then we would say they have assessed that with the proposed rule and with the economic assessment. So they,
In the RIA or without getting into the RIA?
without getting into the RIA, I think the economic assessment was rational. When you look at, and if you may, I'm going to discuss the remediation process because I think it becomes very clear when you look at this why the sort of precision they were looking for can't be provided at this stage. The remediation process begins with a comprehensive analysis of the contaminants at site. What is driving the remedy? Then EPA at a given site considers the feasibility analysis, which are what are the different options for remediating the contamination and how much do they cost? That can range from monitored natural recovery, which costs very little, to digging everything up and disposing of it in a hazardous waste landfill. And then EPA applies 8 different factors from the NCP.
I think we're familiar with the
Okay.
process here.
My point is that when EPA lists a Superfund site, it has no idea how much the remediation of that site is going to cost. Here we are stages before that and making the decision on a nationwide level. So it was perfectly reasonable for EPA to quantify direct costs and to qualitatively assess indirect costs in this case, Your Honor.
Any questions? No. Thank you very much, Counsel.
Thank you.
Helen will give you 3 minutes.
Thank you, Your Honor. I think what I'd like to sort of hit is, I think there may be tough critical materials cases, but this really shouldn't be one of them. We're talking about something that started as a 20-page economic assessment that EPA said it was not only not looking at, but couldn't look at, and has turned into a 300-page RIA. And the agency's position here is that they can throw a 300-page document at the wall and say that there's some uncertainty. And
Are agencies
Even-
allowed in an NPRM to say, this is what we think the statute requires, but we're interested in your views, and then change their mind?
yes, Your Honor, they are. And that gets to
Is
the
that a notice problem if they didn't?
not under the logical outgrowth doctrine, but what we're talking about here is the critical materials analysis. And the agency's position here is that because they did a totality
We
of
have to do a whole nother notice and comment and say, oh, that was persuasive. Okay, so now notice and comment on this. That's what you want. Is you want, there should have been another round of notice and comment.
on the methodologies behind the quantitative assessments and on some of these qualitative conclusions about treating costs
I
as
assume that
benefits.
EPA was just running into the CRA deadline at the end of the administration. Is perhaps why they did not do another.
I would not be in a position to speculate on that, Your Honor.
You've seen
But-
a lot of 3-round notice and comments or 2 double notice and comments like that?
There are supplemental notice and comments that are done, and
Supplemental like this. I'm talking about, this would have been a very comprehensive one like that, where they go, we think this is our view of the statute, but let us know your views otherwise. So on legal question,
Your Honor,
they come back with an answer to that legal question and information. And then they go, okay, we now agree with your position on that legal question. And now here's a new notice and comment.
I have not seen a case like this one where they said they were not going to do, they were precluded from doing a cost benefit analysis and then did a
Not
300-page.
precluded from doing it, that the statute didn't require it. That's a different thing.
They said it was, they were precluded from doing it. That was,
But the statute doesn't require it here, but doesn't mean.
no, they said the stat.
People have, they say, but that's not going to influence our decision. I mean, what the statute would preclude them from doing is, I think in their view, is if we thought it was going to be very expensive, but this thing was as hazardous all get out, we can just declare it not hazardous.
It would preclude them from taking it into account.
So this was a supplement.
But I think the main issue here is their contention is that this material is not critical because they said, even though the preamble says that they considered the quantitative analysis, that they said that there was still some uncertainty that the RIA didn't take into account all of these things. And I think just the most important point on this is there are places in the RIA and in the totality of the circumstances where they specifically talk about quantitative benefits that they could take or leave in their analysis. And they did not do that with respect to all of the things that we are complaining about. And
This only matters, the procedural point only matters to the extent that you would have had something useful to say.
yes, Your Honor.
So would you have had anything useful to say other than with regard to the specific substantive arguments you've made on arbitrariness?
In terms of the cost benefit analysis.
Yeah, whatever criticism, critiques of the methodology, you've made 4 or 5 on the back end now that you've seen the methodology, points where you say the agency acted arbitrarily. Right.
Yes.
And I'll spot you, for purposes of this question, I'll spot you that you don't need to win those arguments to establish prejudice
Yes.
on your procedural point.
So, Your Honor, if your question is,
Is there anything else?
are there other prejudicial arguments that we didn't make, that we left on the cutting room floor? I would think there are others. I think within the limits of the words, we set forth what we thought were the best ones.
Okay.
I think the treating costs as benefits discussion that was had with Judge Rao is, I think, as illustrative or exemplary as you can get in terms of the need for notice and comment. You heard government counsel here today walk away from what we read the rule to do, which is to treat these enforcement costs as benefits. And he says, we categorically, I'm putting words in his mouth, he said categorically, but he says, we don't think that that is an appropriate thing to do. Well, that would have been a nice conversation to have in the notice and comment process. And maybe we can disagree about what the preamble says, although I think it's pretty clear in my own mind. It says we view the cleanup monies, movies, but the cleanup monies as an advantage of the rule. I don't know how you can read it another way, but the point is, we shouldn't be having this debate here a year later in court. And then the one final point I wanted to make was he did acknowledge that if it cost, Your Honor, maybe your hypothetical is it cost $2 trillion or something, or maybe he said $2 trillion. The other thing, there's been a lot of talk about the numbers. I think that's only part of it. But one thing I do want to clarify, the 18 million and the 51 million, the upper end of the ranges that we're talking about, those are annualized over 77 years. When you look at them in terms of present day cost, and it's in here, JA 535, the present value cost of the 18 million is 721 million. And the present day cost of the 51 million is 2 billion. 2 billion with
present value of that cost stream discounted.
2 billion with a B, to borrow from a former colleague of yours who was invoked Judge Kavanaugh. So I think it's important. We're not talking about we're not talking about chump change here, but of course the quantitative complaints are only part of our issue. Thank you very much.
Thank you very much to all counsel. The case is submitted.
This honorable court has adjourned the Thursday, January 22nd at 9:30 a.m.